Honour. I'll closing submissions. Your Honour should have received I'm afraid,
I did. Well, if you're going to
a
send
note riddled with typographical errors, etc., but a note nonetheless.
I got the note, I got your authorities, and I also got your authorities, for which many thanks.
You should have, Your Honour. There is as it were, crib sheet that I'm also preparing that has the references.
Right.
I haven't had a chance to send it this morning, partly because the way we planned it was I would have tomorrow and then phone would have today. It may be that I end up starting today, but what I'll do is send it overnight so Your Honour has the full references.
Very good. Thank you.
Your Honour, this is I think the first point to make clear is this is a claim against an authorised firm regulated by the DFSA and providing services within this jurisdiction and in the region generally. Rule 4.2.1 of the DFSA rulebook, general module, sets out principle 1, which is entitled integrity. What that actually says, it can be found in our authorities bundle at E1 5.1, page 2, is that an authorised firm must observe high standards of integrity and fair dealing. It was telling in my submission that when I put to Mr. Swats that an authorised firm is required to act with integrity, he said, I didn't know that, or I don't know that. And Your Honour will find that, I won't go there, but it's day 3, page 169, lines 11 to 17. The evidence provided by Ribble has been, in my submission, far from open and far from frank. Mr. Swats was, in my submission, a positively evasive witness, and certainly a witness who was very reluctant to admit anything, even when it was patently obvious. The defence mounted by Ribble is a technical defence rather than a defence, if you like, on the merits. It relies on pleading points, it relies on disclaimers, and it relies on something referred to as the subscription agreement, which it purports to have entered into on our behalf and bound ALAWWAL to all sorts of understanding positions, rather than seeking to demonstrate that what was said was not misleading at all. Indeed, without any explanation or reasons, Ribble has failed to call Mr. Zographos, who was at the heart of this case, and Mr. Lomonaco, who also played a role, and Mr. Aker, who all attended meetings and could presumably have given evidence regarding what was said at those meetings. Now, Mr. Zographos obviously attended all of those meetings, the 14th of November, 23rd of January, 6th of February and 25th of February. Mr. Lomonaco attended the 23rd of January and the 6th of February meeting. Mr. Aker attended the 25th of February meeting. All of those people could presumably have said something about what was said, but they have not been called. No explanation has been provided at all. Mr. Swats was asked about it, and he in fact stated that he had no knowledge of these decisions. He accepted that Mr. Lomonaco was still working for Ribble here in the DIFC.
What inferences do you say that I should draw from the fact that these witnesses haven't been called?
Well, in my note, I refer to a couple of cases which deal with that. I'll just remind myself of the references. It's Wisniewski and Central Manchester Health Authority.
Sorry, which paragraph are you looking at?
I'm looking at paragraph 28 of my outline submissions.
Yeah.
And what I say there is the court may draw inferences when a party fails to call a witness who is expected to provide material evidence.
Now, the question is what inferences?
Well, the inferences as I go on are either that the case, either our evidence is strengthened by that, or the evidence or the case of the other side is weakened. I think it's useful to go to Wisniewski, and I think it's been uploaded onto our authorities bundle. I don't know if your honour has it.
So I downloaded the authorities you sent through, but if they're on Opus, I'll look at them there.
Yes, I'm.
It's E1 tab 12.
Sorry.
E1 tab 12.
I'm grateful. It's apparently E1 tab 12. And I'm still looking at it just in the raw form and have marked it up accordingly there. It's actually, in terms of that particular transcript or particular report, which was downloaded, it's page 13 of that. I'm not 100% sure what the internal numbering will be. I suspect it will be page 13.
Yeah.
And it's from the bottom of that page where, having reviewed the authorities, the judge says, from this line of authority, I derive the following principles in the context of the present case. In certain circumstances, a court may entitle to draw adverse inferences from the absence or silence of a witness who might be expected to have material evidence to give on an issue in an action. If a court is willing to draw such inferences, they may go to strengthen the evidence adduced on that issue by the other party, or to weaken the evidence, if any, adduced by the party who might reasonably have been expected to call the witness. There must, however, have been some evidence, however weak, adduced by the former on the matter in question before the court is entitled to draw the desired inferences. In other words, there must be a case to answer on that issue. And then at 4, if the reason for the witness's absence or silence satisfies the court, then no such adverse inference may be drawn. If, on the other hand, there is some credible explanation given, even if it's not wholly satisfactory, the potentially detrimental effect of his or her absence or silence may be reduced or nullified. So we have produced evidence. Mr. Al-Ibrahim has produced evidence of what was said at each of those meetings, apart from the 6th of February. Mr. Malaika has produced evidence of what was said on the 6th of February. The failure to produce those witnesses, to call those witnesses who might reasonably have been expected to give evidence on what happened at those meetings, which are highly material events, strengthens the evidence in my submission of Mr. Al-Ibrahim and Mr. Malaika.
I mean, the normal inference which parties ask to be drawn is that the evidence of the witness concerned would not have assisted, in this case, the defendant's case. Is that the inference? I mean, simply saying, well, it strengthens it doesn't really go much further. I think this is dealt with in some of the authorities subsequent to Wisniewski. But is that the inference which you seek to draw in this case?
Well, the inference that I seek to draw is that Mr. Al-Ibrahim and Mr. Malaika are being truthful and telling the truth as to what happened, and that the reason that Mr. Zografos and Mr. Lomonaco have not been called is because they would not have contradicted that evidence and would not have assisted the case of Ribble in this regard. And so in those circumstances, you should find that the evidence of Mr. Al-Ibrahim and Mr. Malaika is to be relied on in terms of what they say. Now that applies obviously in terms of the meetings on the 14th of November, 23rd of January and 25th of February, but in my submission it also applies in relation to the meeting on the 6th of February, because both Mr. Zografos and Mr. Lomonaco were there. The two witnesses who have been called can, on their own admission, not remember anything about the meetings, although they say they would not have said the things that are alleged.
I'm not sure that's entirely fair. I mean, I think the way I see the evidence which is being called about that, it appears to me that really what's being said about the 6th of February meeting is that they can remember going through the PowerPoint more than that, or they can remember the PowerPoint being gone through, but not much more than that. But anyway,
I think when I come to it, I won't go out of my course. When I come to it, I think I'll take you to a passage where Mr. Bitcon accepted that he didn't remember anything.
well, I mean, maybe I'm wrong to take both
Yeah.
emphasis. Anyway, yeah. Okay.
So what I'm saying in any event is that Your Honour should accept Mr. Ali Ibrahim and Mr. Malaika's evidence as regards what happened at those meetings.
Yeah. Okay.
I've referred to Mazoon only because it's a case in which a judge in this jurisdiction has referred to, at paragraph, I think it's 56 of the judgment in that case, and referred to Wisniewski, although in that case he didn't think it appropriate to draw any adverse inferences. He clearly indicated that that was a case that this court approved of and would have followed. Now, Ribble has, in my submission, demonstrated that in terms of the way it is operating, all is not what it appears, and there is, in my submission, a lack of transparency. Now, I'll go into that in due course, but there are a few headline points to be made in that regard. There are, in my submission, serious regulatory issues regarding the management of the fund. It clearly, on the facts, if one looks at what actually happened, that fund was managed here within the DIFC by Ribble. We have this insistence, excuse me, that it was all that the fund was managed by its directors, and that it was managed in accordance with the investment management agreement. Mr. Bitcon accepted that the investment management agreement and the offering memorandum were inconsistent in one regard, the only regard that was put to him, and it was quite clear that Mr. Swats knew very little about the management of the fund, and it was quite clear that it was all done by Mr. Bitcon and Mr. Jones, etc. And also that, as we went through that, we could see that they were carrying out functions that had nothing to do with investment management and were all to do with fund management. The second headline is that...
And just on that,
Yes.
We looked, as you said, briefly at the investment management agreement in the context of Mr. Bitcon's evidence. In your note, you effectively asked me to treat the investment management agreement as being a sham.
I've called it window dressing, yes.
If there's a difference. No,
I just referred to what I said.
Tell me what that is. Now, I mean, I've got well on board the fact that, I think literally the only presence of the fund in Cayman Islands appears to be a brass plate.
Yes.
And Mr. Swat said he'd never been to the offices in Cayman. This isn't a case which you very often see where the board meetings of the fund are carefully identified as taking place in Cayman, or they've got Cayman directors who are resident in Cayman, or anything of that nature. But it would help me, I think, if at some stage you were to identify what provisions it is of the investment management agreement which you say, well, to use your words, a window dressing.
Well, I think probably, to take a step back, I'm not suggesting for one moment that Ribble was not managing the investment. What I am suggesting is window dressing is to suggest that the role of Ribble was confined to investment management.
Well, that was what I was going to ask you, really, because as I read the relevant statutory provisions, there's a factual question as to who is managing the fund.
Indeed, yes.
Now, the investments are being managed by Ribble, and
Yes.
that's common ground.
Yes.
Fine. The fact that the investments are being run by Ribble or being managed by Ribble doesn't mean that other things, the management of the fund as a whole isn't being managed by Ribble.
Yes.
So I'm slightly wondering why you say the investment management agreement is a sham or window dressing, as opposed to simply saying that on the facts in this case, I mean, the one director that is being called of the fund doesn't seem to have been actively involved in managing the fund to any considerable extent.
No.
And in any event, he's a director of Ribble, he's resident here in the UAE, etc., etc. So I'm slightly wondering where this window dressing comes in.
It may be that that's not an apt choice of term in terms of describing the investment management, because as I've said to you, I don't suggest for one moment that Ribble is not managing the investments. Of course it is. What it is doing, though, is an awful lot more than that. I think probably what is window dressing or what is a sham is the case that it is advanced that the fund is managed by its directors and Ribble's sole role is to manage the investments in accordance with the investment management agreement.
Right.
In other words, putting forward the investment management agreement as being the sole raison d'etre of Ribble as far as the fund is concerned.
Yeah.
That I suppose is what I meant, and I see Your Honour's point that perhaps window dressing may not be the most apt term to describe it. But if that is put forward as being the raison d'etre and all four corners of the role of Ribble in this fund, then that is in my submission. In that respect, window dressing, because it clearly isn't. It's quite clear that Ribble was managing investments, but it was also doing everything else. It was liaising with auditors, it was instructing auditors, it was instructing solicitors, it was managing litigation, it was dealing with regulatory matters, compliance matters, etc. All of that was being done by Ribble, and that's clear from the minutes of the board meetings and from the cross-examination. None of that was being done by Mr. Swats. And so the pleaded case that the fund was managed by its directors is completely wrong. And there were two directors. It's not been suggested that the position of Mr. Krishnan was any different, and if it was, then he should have been called. Yeah. The second headline point is that under the Conduct of Business Rules 3.4.2, which again Your Honour will find at Bundle E1 tab 5, page 4, there is an obligation to undertake a suitability assessment for any investment that a client is making. And we went through this quite a bit on cross-examination with both Mr. Swats and Mr. Bitcon. And we had this situation, and we looked at their terms of business, clause 3A of the terms of business, because we will assess suitability on the basis of the application form. We looked at the application form, medium risk, low risk, and then we looked at that exchange of emails on the 19th of February 2019 between Mr. Zographos and Mrs. Vyas. And for no reason that one can fathom, compliance people are told that the risk tolerance of ALAWWAL is high. So there was a complete fudging of the regulatory compliance process. The third headline point is this reliance on the 2017 accounts. Now, they are relied on as having been the disclosure. Of course we've made adequate disclosure, look at those accounts, and of course we wouldn't have said that in the meetings because...
Well, I think the way they're relied on in relation, as I understand it, isn't disclosure of everything, but it's disclosure in particular of the fact that there had been failures to pay in accordance with the provisions. I think is probably the fairest way of putting it.
Yes. What one sees when one looks at those accounts, however, is that they are in themselves misleading, in my submission. The failure to take an impairment in relation to net trade is unaccountable and unjustifiable, and indeed Mr. Bitcon and Mr. Swats struggled to explain why that was the case. The note in respect of Farlin at note 16, and I'm going to come on to that in a moment, is positively misleading. So we have that, which is one of the documents that are relied on, and perhaps is one of the documents where it is not clear, fair, and not misleading, which is the obligation of an authorised firm. The fourth headline point is that the RFP document, which is an important document in my submission, was provided to ALAWWAL in answer to a specific question about risk mitigation policies, procedures and controls. But Ribble is saying, notwithstanding that, it is maintaining its case that ALAWWAL was not entitled to rely on it. That's where I'm talking about this very technical case rather than looking at the realities of the situation. The fifth point, headline point, is this issue of losses were all caused by COVID. And that is what the fund was telling its investors when it ceased to allow redemptions, etc. But as we have been through the evidence, insofar as we have adequate disclosure to see it, we see that, firstly, very, very substantial losses had already been incurred before ALAWWAL had even invested. We had the Met Trade losses, we had Farlin, and then as we go through it, there were a lot of others. I'll deal with this in due course. So I think it was pretty much accepted. I mean, Mr. Swats would only say, I knew the financial circumstances of the fund, but it's pretty much accepted that on the 6th of February, there were defaults totaling about $35 million at that stage, albeit there was some credit insurance. We also see that after those dates, as one goes through the minutes, after the ALAWWAL investment and before COVID, there were other defaults. And we see the Tricom forfeiting fund, where the notes in their accounts say this impairment is not due to COVID. That hasn't increased the risk at all. And you're getting to a point where at the time of the COVID outbreak, there was probably in excess of $60 million US dollars of default. Whether you add the 17 million let's put it a different way. Sorry, that might not be quite right. But there is at least 60 million that you can say was nothing to do with COVID, either because it was before or because the Tricom 40 fund accounts say that it was not the risk was not increased by COVID. When there are that amount of substantial losses, it is clearly misleading to be telling investors this is all down to COVID. My submission would be that this was being used as a convenient excuse for their own failings.
Now, just on, I'm sorry, there's one point I want to go back to. Yes. About fund management.
Yes.
And it arises from the collective investment law, which is, for these purposes, to be found at bundle E1, tab 4, page 14.
I'm there, Your Honour.
And subparagraph 2 says, for the purpose of this law.
Sorry, in case I haven't got the right numbering, which provision are we looking at?
Sorry, we're looking at provision 20, subparagraph 2. Roles and functions of the fund manager and the trustee.
Yeah.
For the purpose of this law, or any other DFSA administered law, or any rules made for the purpose of these laws, the person who manages a fund, subject to Article 23, is the person who, A, is legally accountable to the unit holders in the fund for the management of the fund, including the property held for or within the fund property, and B, establishes, manages, or otherwise operates or winds up the fund. Now, how do you say that Ribble is legally accountable to the unit holders for the management of the fund?
Now, obviously, I say that B is satisfied there.
Well, that's a factual
yeah,
question.
Yeah,
And I
a
understand
factual
what you
question.
say about that.
I think the way the argument must necessarily work is that so far as any management is being carried out, and that including the management of the investments, etc., that and insofar as unit holders or shareholders in the fund will have any redress, that redress is going to be necessarily against Ribble, because Ribble is the entity that is doing everything. And so if, shareholders very rarely have any redress against, shall we say, a director. So on Ribble's case, A there will be the directors of the fund. But if you look at the reality of that situation as to a shareholder who has bought shares in a fund, because of the rule against reflective loss, and because of the rule in Foss and Harbottle, none of those shareholders can actually sue a director because the proper plaintiff there is the company. And so query how you actually establish that accountability at all on Ribble's case. The way that that is done or could be done is through some sort of derivative action that can be brought in the Cayman Islands, because they recognise the common law, and I think also they have a statutory derivative action. But in those circumstances, those unit holders, those shareholders, would be able to, on behalf of the company, seek recompense, hold accountable whoever is actually responsible for that default. And that isn't necessarily confined to the directors of the company, although they could, by that same mechanism, be held to account, but would also be someone who has breached their duties in some way, caused the loss, and so accountability to the unit holders of the fund is a strange concept because of the mechanisms that I've described, but insofar as they can be held accountable, the directors are no more easily held accountable than Ribble, and the reality is the party to be held accountable is the party who was actually managing the investment, managing the units, and undertaking the management of the fund. So if Your Honour decides that Ribble comes within B, then in my submission, in the circumstances I've described, it necessarily also comes within A.
Well, let's just test this a bit. Subject to derivative actions, as we well know, shareholders don't have individual claims against directors. The shareholders as a body, of course, do have claims against directors, and that's the basis upon which claims can be brought by liquidators, etc., against former directors. Now, if one looks at 2, the person is the person who is legally accountable to the unit holders in the fund. I don't see why that shouldn't be said to be legally accountable to the unit holders, brackets, as a body. It's not saying to a unit holder who would be legally accountable to a unit holder. Now that does point very firmly towards the directors.
Well, can I
just let me finish my point. And then you've got and establishes, manages, or otherwise, or winds up the fund. Now, in the ordinary course of events, that would also be the directors. But if it's someone else, you've got an oddity, because you've got potentially the directors being A and someone else being B. Now, one possibility would be people who would account as shadow directors, in other words, who actually are carrying on the business, and if you had a shadow director, they would be legally accountable to the unit holders as shadow directors. But I don't think you developed that case. But one possibility is that in the circumstances of this case, that's really what Ribble were doing.
Taking that in stages, in terms of who establishes, manages, or otherwise operates the fund, I don't think in my submission that is necessarily the directors. Directors need not necessarily.
No, they could pass it on to someone else. But my point is, if they pass it on to someone else, if they pass responsibility on to someone else, so that the company or the unit holders as a body could sue them, then you've potentially got a difference between A and B. That's the point I'm making. So you could end up with a situation where you have neither A nor B. Sorry, you have one person doing A and another doing B, and therefore you don't have someone who's a fund manager for the purposes of two.
A, Your Honour said the directors are responsible to the shareholders as a body. That only works on the basis that the shareholders, as a majority, take control of the company and cause it to take action against the directors. It doesn't cut through the rule in Foss and Harbuttle and the separate identity. Shareholders as a group have no beneficial interest in the assets of the company. They have all they have is rights in the winding up, etc., and the rights to attend meetings and the rights that are annexed to or attendant upon their shares. So there isn't really much difference between a derivative action, which is shareholders, a minority of shareholders getting permission to take action on behalf of the company with the sanction of the court, or the majority of the shareholders actually physically taking control of the company and effectively stepping into the shoes of directors to sue certain individuals. So in that case, and liquidators suing on behalf of the company, that's not because they step into the shoes of the shareholders, it's because they effectively take control and step into the shoes of the directors, de facto, as far as the causing of proceedings to be brought is the case. So,
just on this, where does is 22 mirroring a provision to be found elsewhere, and in particular in English English regulation or not?
I have to say that I'm not sure about that, Your Honour. I don't know.
I mean, it's just that when one looks at 22, it's well, to my mind, it's an odd provision as to what it is that's getting to, because what it looks like is it's requiring both legal accountability and establishing managerial or otherwise operation.
I agree. When I first looked at it, I thought, well, this rather obfuscates the matter rather than clarifying it, and it is in my submission a provision that is going to require a slightly purposive interpretation, judicial interpretation. What is it intending to achieve? And what it is clearly tending to achieve is ensuring that the person who is managing the fund is properly held to account for that, and that fund managers cannot hide behind smoke screens, etc., to evade their responsibilities. That must be the purpose of the litigation, that fund managers are properly identified. That clearly is what is happening at B. The issue is in my submission A. Now, as I've said, whether or not Ribble is a shadow or a de facto director, it would still be held accountable on the basis of a derivative action or on the basis of shareholders taking control of the company. It can be, in my submission actually, the more likely finding would be not so much a shadow director, because a shadow director directs the directors and tells the directors what they should do, but it's actually a de facto director. So what I think we are saying is that Ribble was de facto a director of the company because it was de facto carrying out the management of the company. Now, we have said, Your Honour said we haven't really developed that case. What we have said is Ribble was managing the fund. If you manage the fund, carry out the duties of the directors, then you become a de facto director. So whilst we haven't used the term de facto, what we have done is identified the fact that Ribble is managing the fund. Now, in my submission, that, on the basis of a slightly purposive interpretation of 22A, is exactly what that involves. So if you have, I mean, someone, if the fund is managed by its directors or had been managed by its directors, then it would have to have established both A and B, because someone must be held to account as the fund manager. If actually the directors were doing nothing, and that appears to be the case, and were mere figureheads, and it was Ribble who established, managed and operated the fund, and it was actually Ribble whose reason was a de facto fund, or the individuals were the individual representatives of Ribble, then that also in my submission ticks box A, or sub-article A, and that in my submission is to how one works one's way through it.
I mean, you'd ordinarily expect legal accountability to cause you to look at the memorandum and articles. And the memorandum and articles effectively give the directors the power to appoint an administrator, we've got the mem and arts at G5 tab 4. And administrator is defined as the person, firm or corporation appointed and from time to time acting as administrator of the company.
Sorry, Your Honour,
Sorry.
that reference.
Sorry, that's the definition at
It's tab 5.
yeah,
at page 4, I think. G tab 5, page 4.
yeah, I'm there.
And the sorry, somewhere. 3.1 at page 9 authorises the directors to appoint a person, firm or corporation to act as a service provider to the company.
Yeah.
And 3.2 authorises the directors to appoint an investment manager. And those seem to me to be the relevant relevant provisions. And so I suppose that the question I've got is, well, how does legal accountability work given this memorandum and articles as against Ribble for something which is within, for something which is fund management, but not investment management?
Well, I mean, notwithstanding the memorandum and articles there and the provisions you've just looked at, the directors would have had the power, the ability to appoint all those people in any event, just because they are directors and they, with them is charged the management of the company.
Well, I think that would be because of Table A or whatever the usual provisions were. I mean, you could write that power out.
I suppose you could, but it would be strange if a director couldn't manage a
Well,
company.
I agree, but I mean,
Yeah.
it's coming about because of this rather strange
Yes.
language that I'm trying to get to grips with. And
Sure.
I can't, well,
So what,
I can't help but think there must be a reason for the language.
a reason for...
Well, a reason for the provisions of the requirement for legal accountability
Yes.
and factual operation. That's what I'm struggling with.
In my submission, what 20 is seeking to do is to identify who is the fund manager.
I agree.
Not so that they can be held necessarily accountable by any particular individual unit holder, whatever, but so that they are accountable potentially to the DFSA or potentially to third parties or whatever for having complied with their obligations under the regulatory system.
I don't think that can't be right, can it? Because 20A is legally accountable to the unit holders for the management of the fund.
But that is for identification purposes, is the point I'm making. So this is saying who is the fund manager for the purposes of these regulations or these articles and for the purpose of the regulatory system. This is how one identifies who the fund manager is. Now, once one has done that, all sorts of consequences flow from that. And for instance, when we refer in our pleading to duties that are owed by the fund manager, RIBL's response is, we're not the fund manager, that has no application to us. And so one of the purposes of 20 is to enable the court, enable people, enable the regulatory system to identify who actually is the fund manager. Now, within that, what this is saying is there are two indicators, requirements for identification of that fund manager. One is that they establish, manage, or otherwise operate or wind up the fund. That one is obvious, and that's the realities of the situation. The second is the slightly more nebulous one, and is slightly more problematical, and the one that in my submission requires a slightly purposive interpretation. And that is that they are legally accountable to unit holders. And one has to then look at what that exactly means. And I think if one goes through, as far as I can see, the memorandum and articles, they don't actually provide any provision in there by which unit holders or shareholders could hold accountable the directors or indeed anyone else relating to the fund. What one therefore has to do is to look more broadly at the general law and say, well, how does this happen? How would unit holders, shareholders, hold anyone accountable? And that would only be through some derivative action or by taking control of the company. But that is not really confined just then to the directors. It could be more broad, but it would certainly cover the directors, which includes the de facto directors. So if one actually is trying to establish a connection, a line between B and A, what is the commonality there? Necessarily, it is manages the fund. Because if you manage a company, then you are, depending on the level of management you undertake, is a strong argument that you are a de facto director of that. I think it is de facto that Your Honour is thinking of here, rather than someone lurking in the shadows and being a shadow director. So, in my submission, RIBL and its personnel are managing the fund, is a de facto director of the fund, and could be held accountable, as could the directors, for the management of the fund, but through that derivative action procedure. So it's somewhat vague as to how, in a common law company, anyone can be held, a director can be held directly accountable by a shareholder. But insofar as there is a way of doing it, in my submission, that is the only way that it can actually happen.
Okay.
final sort of headline I was going through is that the fund is the subject, this is talking about transparency, of a just and equitable winding up petition in Cayman at present, where lack of transparency is one of the main grounds, main complaints being made and main reasons being advanced to the Grand Court in the Cayman Islands as to why they should wind up this company on the just and equitable ground. Now, Rule 3.2.1 of the Conduct of Business Rules requires an authorised firm to ensure that its communications are clear, fair, and not misleading. We say that it has clearly not complied with these obligations. The misrepresentations that we're alleging were a breach of that particular provision and provisions of the collective investment law, which I'll come on to. But it is this lack of transparency, the failure to comply with statutory obligations of being clear, fair, and not misleading, that runs is the thread, if you like, running through this particular case. Now, what we are asserting in this case is that we have suffered loss as a result of being induced to invest in the fund by a series of oral and written misrepresentations, which we say were made negligently, in breach of statutory duty and in breach of fiduciary duty. Those representations relate primarily to the risk profile of the fund, the investment, and also the risk mitigation measures that are applied. We say that because of Conduct of Business Rule 3.2.2, RIBL cannot actually exclude its liability as far as that breach of statutory duty is concerned. And one of the themes I'll be developing is that there may be all sorts of arguments regarding the negligence claim, but in terms of the breach of statutory duty claim, which covers the same representation, so we say that those representations were made negligently, but were also made in breach of statutory duty. We say that none of those actual arguments can stand in the face of that breach of duty claim. Now, we seek damages and compensation to put us in the position that we would have been had we not invested in the fund. And in terms of the statutory claim, that is made under Article 94 of the regulatory law. And we also seek compensation to reflect the opportunity cost of having made that investment in the fund. Now, RIBL denies any liability for the losses suffered. It variously denies the oral representations. It disputes the meaning of some of the written representations. But I mean, the thrust of it, of their defence on this, is that ALAWWAL was not entitled to rely on anything that was said. It does that, and it gets there in two ways. One, it says it wasn't reasonable for it to rely on it, and the second point is the disclaimers. But as far as reasonableness is, it says that ALAWWAL was not entitled to rely on the representations, and it was unreasonable for it to do so. It says that RIBL did not intend ALAWWAL to rely on the representations, and it also says that RIBL could not reasonably have seen that ALAWWAL would rely on the representations. We say that in the circumstances of this case and on the facts, is just not a tenable argument. As I've said, the second line of defence on that is the disclaimers, by which they say they preclude reliance, and they also seek to exclude liability. And then the third is this subscription agreement, which they say actually contains provisions, clauses, terms, which exclude any liability and prevent reliance as well, and also acknowledge that one has read this, agrees the other, etc. So it's essentially basis clauses, which they say exist in the subscription agreement. Looking at I was then going to deal with the fund manager. It may be that we that there's nothing more to say because we've effectively discussed this fully. The regulatory matters that flow from that is that they have said they are not the fund manager, and they have said that the fund is not an external fund, it is a foreign fund. So we have the categorisation.
It's not a domestic fund.
Sorry?
It's not a domestic fund, it's a foreign fund.
Yes, I think the categories, we alleged it was an external fund because it was domiciled overseas but was managed within the DIFC.
Yeah.
They said it's not an external fund. Implicitly, they seem to be saying it was a foreign fund.
Yeah.
But they didn't actually pin their colours to the mast at all. So that's the issue. Now I've already made submissions, and Your Honour and I have had exchanges regarding what we say about the management of the fund. And essentially the submission is that the evidence that's before the court, the minutes of the meetings of the Board of Directors and the cross-examination demonstrate that insofar as the fund was being managed, it wasn't being managed by its directors, it was being managed by Ribble. Mr. Bitcon admitted an inconsistency between the investment management agreement and the offering memorandum. You have that reference. I don't know if I've got the references in my note. Does Your Honour want me to give them to you again for the benefit of the transcript, or
No, because I'm going to be able to. They'll be in the note.
yes.
Which will be.
So I won't trouble myself too much with unless we actually need to go there.
No.
He refused to accept, and Mr. Swats refused to accept that Ribble was actually managing the fund, and in my submission that is evidence of the evasive nature of some of the evidence that was given on this, and the refusal of a witness to admit something that is patently obvious, and sticking to the party line, was, in my submission, some of the concerns that one necessarily has about Ribble's witnesses. There was, and one of the things was when it was put to Mr. Swats that the fund was being managed by people who were sitting here in the DIFC, and their presence here, their visas related to their employment by Ribble, he immediately said, "Oh, I have a golden visa." Then when we drilled down into it, at the time in question, he didn't have a golden visa. His visa was relating to his employment with Ribble. So anything he did here within the DIFC depended on his visa, and that depended on his employment by Ribble. Principle 1 for the principles for authorised firm must observe high standards of integrity and fair dealing. A failure to be open and frank and honest about the management of a fund, in my submission, breaches that principle, number 1, about integrity and fair dealing. Mr. Swats was the boss, he was the CEO, he set the tone, and we saw from his evidence that he was anything but transparent, and he was, in my submission, evasive. It's symptomatic of the malaise within this company that there is not transparency. Now, I've got to look now at the witnesses that were called. Mr. Al Ibrahim was the first witness called by ALAWWAL. He was important because he was central to everything that went on in terms of the assessment of the investment, but he also most particularly attended meetings on the 14th of November, 23rd of January and 25th of February, and he was involved in the recommendations and why the recommendations were made to the ALAWWAL Investment Committee. My submission to Your Honour is that he was a palpably honest witness who endeavoured to answer the questions that were put to him frankly and truthfully, and he was prepared to accept matters that were not necessarily in his favour when it was clear that they were the truth. And so he was an honest witness in that regard. His command of English was not perfect, is not perfect, and is certainly not as good as Mr. Malaika's. And on occasions he struggled to understand certain questions that were put to him and had to ask for them to be repeated, and occasionally struggled to also express himself and give answers. And that may have impacted on the quality of the answers that he was able to give. But he had a very good recollection of events, including what was said at the meetings that he attended. And my submission is that Your Honour should rely on his evidence. The second witness, Mr. Malaika, is the CEO. He was obviously involved on the Business Development Committee of ALAWWAL and the recommendations that were made, but he most particularly attended the meeting on the 6th of February. Now, in my submission, like Mr. Ali Ibrahim, Mr. Malaika was an honest witness. He was a little more combative than Mr. Ali Ibrahim, but it is material in my submission, as Your Honour observes his demeanour in the witness box, that he's extremely loquacious. He has an awful lot to say, and the idea that he would have sat in the 6th of February meeting saying very little at all and just listening and taking it in and not ask questions is, in my submission, extremely unlikely, and should make Your Honour somewhat doubt the suggestion that that is indeed what happened, that is advanced by Mr. Bitcon and Mr. Swartz, albeit in circumstances where they say they can't really remember what happened. He had a recollection, a clear recollection of the meeting. He clearly recalled, he said, the questions that he asked and the answers that he received. And in my submission, Your Honour should also rely on his evidence as being honest evidence. Now, as I previously said, Ribble's witnesses of fact were strangely chosen in some regards, because they were two people who, in terms of interaction with ALAWWAL, had a lot less than other witnesses who could have been called. We've already discussed the failure to call Mr. Zographos, Mr. Lomonoko, and Mr. Aker. The first witness, Mr. Swartz, was a director of the fund and was the CEO of Ribble at the time, as I understand it. Now, he was, in my submission, an extremely evasive witness and was extremely reluctant to admit anything that was not in Ribble's favour, even obvious facts. Your Honour had a discussion with him about the difference between mitigants and security structural enhancements, with him insisting that certain matters were the second and not the former, until he was eventually compelled to reluctantly agree that there potentially, in certain circumstances, wasn't much difference between the two. He was insistent that there were not defaults, there were past dues, and he would, although saying he couldn't remember what happened the 6th of February, that lack of recollection for him was taken as a denial that questions were asked by Mr. Malaika and answers given. He refused to accept that the reduction of assets under management of $50 million between November 2018 and February 2019 had caused liquidity issues for the fund, despite there being evidence in the minutes that there was liquidity issues raised by that. when pressed, he admitted that he was fully aware of the financial position of the fund, although he was reluctant to admit that it was sitting on defaults of $35 million. He had no recollection of what was said at the 6th of February meeting or who intended it, but as I've said, he notwithstanding, insisted he was able to say that what Mr. Malaika had said or had not said, and was insistent that he hadn't asked many questions. In my submission, Your Honour should be very wary of relying on the evidence of Mr. Swats unless it is corroborated by contemporaneous documentary evidence. Mr. Bitcon was a likeable and slightly earnest witness. At the commencement of his evidence, he made an amendment to refer to IFRS 9 in one of the paragraphs. In my submission, that raised the suspicion, at least, that there had been discussions overnight after Mr. Swats had struggled greatly in dealing with or explaining the 27. That wasn't put to him, was it? It wasn't put to him, that's true. No. Mr. Pitcairn also struggled to explain, although clearly better versed than Mr. Swats, he struggled to explain why the 2017 accounts did not show any impairment for the debt owed by Mettrade. Like Mr. Swats, he was unwilling to admit facts that were not in Ribble's favour. He refused to admit that Ribble was managing the fund. And on occasions he sought to avoid answering questions by answering a different question. On a couple of occasions I said to him that wasn't the question you asked, and on a couple of occasions I think Your Honour said, Mr. Bitcon, that's not what you were asked. And he had to be brought back to actually answer the question. He said that he had no recollection of that meeting, and yet he sought to deny that the representations were made. I think I've probably addressed you adequately in terms of the adverse inferences that are to be drawn, and I just to say that they should apply to all of the meetings, not merely so in other words, the 6th of February meeting as well. An important point which I refer to, or begin to refer to, at paragraph 29 of my note is the failure. I mean, Your Honour just said to me you didn't put that to Mr. Bitcon regarding overnight discussions of the accounts, and that's quite right, I didn't. Very key elements of the evidence of Mr. Malaika and Mr. Ali Ibrahim were not challenged during cross-examination. As I refer to paragraph 29 of my note, under the rule in Brown and Dunn, you have to challenge evidence in a witness if you're going to suggest that that evidence is untrue.
Well, yes, let's look at your paragraph 31, which is the challenge in relation to paragraph 23, which is the seeking to invest in Sharia-compliant investments with a low risk profile. Now, as is probably apparent from some of the questions I've asked, struggle slightly in relation to what is meant by low risk, medium risk, and high risk. And right at the end of his evidence, the first witness identified low risk as effectively being LIBOR rates,
yes.
LIBOR 3-month rates, I
yes.
think. Mr. Swat gave evidence that...
Sorry, Mr. Swats, did you say?
Mr. Swats gave evidence. Well, at several points, he seemed to be saying that he wasn't... He was saying that the fund was highly speculative. Sorry, he appeared to be saying... He appeared to deny that the fund was highly speculative, although those are the words which in one part of the offering memorandum appear. And the words he fastened on in relation to the offering memorandum were effectively the intention to get, I think, LIBOR plus 5%.
Yeah.
And he was saying, well, that's quite a high rate of return. Now, one of the points that, so I think that's the evidence, such as it is, about where the spectrum comes. The other thing which is apparent from paragraph 31 is that Mr. Malaika was referring to wanting to invest in Sharia-compliant investments with a low-risk profile. Now, I sought to explore whether Sharia compliance adds anything in this context. And in particular, I mean, there are obviously various aspects of Sharia compliance, not investing in gambling, pornography, various other bits and so forth. But also, as I understand it, a prohibition on excess speculation. But I don't think any of the witnesses really supported that. So my question is, what in the context and against the background of these investments is meant by, on the one hand, low risk, then medium risk, and then high risk?
I've got a spreadsheet which I'm going to be passing up shortly, which in a moment, which has been shared with the other side. I think when Mr. Swartz pointed to LIBOR plus 5, as I recall, we may have to check the transcript, but as I recall, it was not by reference to the offering memorandum, but was by reference to the presentation.
I think you're right. Yes, I think that's right.
Yeah, there was and he said, look, it was clear from the presentation that this was a high risk investment because we were targeting LIBOR plus 5.
Yeah.
He said that's high risk. The evidence, I don't think Your Honour had a discussion with Mr. Al Ibrahim about what he exactly meant about what was low, what was high. I mean, I think his start point was that the benchmark of low risk is 3 months LIBOR. That is as low as it gets. And then as you move up through that, now I think the boundaries between low and medium didn't become entirely clear from that exchange, but it was quite clear that he regarded the low risk benchmark as being 3 months LIBOR. Now, what they had done and what Mr. Al Ibrahim's evidence was quite clearly is that they had analysed the volatility of the fund in some detail.
Yeah, now just on that,
Yes.
that's absolutely right. And he referred in particular to the Sharpe ratio.
Yes.
And the critical point about that is that you don't get a low Sharpe ratio means that you do not get swings, if I can put, or substantial swings,
Yes.
in relation to the value of the assets under management.
Yes.
Now that, I mean, one of the interesting points about that, of course, is that I haven't done the maths, but if you, for example, were to make provision for, say, $4 million being the uninsured amount of the $14 million outstanding as at the time of the signing of the 2017 accounts, although that $4 million is only a relatively small percentage of the overall funds under management, if you actually were to make provision of that, it would have quite a significant effect in terms of the Sharpe ratio.
Ratio, yes, deviation.
Because if you look at the amounts, the asset values, they're operating within a tiny sphere. They really don't change very much at all from a month-to-month basis.
No.
And that's not terribly surprising if you're not writing off sums which you're not recovering.
Yes, exactly. Just a couple of points, Your Honour. The sum that was actually outstanding under Mettrade as at the signing off of those accounts was actually still 14 million.
Oh yeah, I appreciate
Yeah.
that. It's still 14 million, but the point which was being made
Those credit insurance for
by
10,
the
yeah.
defendant's witnesses is that you've got credit insurance for 10,
Yeah,
and
exactly.
therefore what they were saying was that you should only make provision for 4. Now,
Yeah.
even accepting that that's right,
Yeah.
one argues say, well, hang on, are the insurers actually willing to pay, and that was insured?
Yeah.
My point is simply that they were saying, well, 4 million is a small amount of the overall fund, and that may well be true, but it still has quite a significant effect on the Sharpe ratio.
Indeed. One of the important points also, which, and I'm jumping ahead a little bit, we'll make in due course was going to, is that if you actually take impairments, record impairments in the balance sheet and the profit and loss account, that would have set in train a course of inquiry, because immediately there are impairments. That would cause people to look properly and understanding what exactly was going on within the fund. A course of inquiry would probably have led to uncovering the fact that at the time they were invested there were $35 million worth of defaults in the fund, taking account of the fact that they'd already had
that point, of course, is well, I think what is being said by Mr. Beru is going to be that if you read the 2017 accounts properly, and even assuming that which he doesn't accept, that there should have been some provision for impairment, he's effectively saying, well, you would expect the notes to be read, and if you read the notes, that causes you to start making inquiry about what's been going on. To which, as I understand it, your answer is, well, the evidence for the witness of the claimants is they didn't, in fact, read the notes, and that's not surprising given that there were no impairments. But I think that's what you say about it.
Yeah, I think also one of the points that I think Mr. Beru is going to be stressing very heavily and has stressed hitherto is that ALAWWAL were sophisticated investors.
Yeah, and you accept that.
And we accept that, yeah. I mean, there's no basis upon which we can't. Yes, of course they were. But in fact, that cuts both ways, because if you are saying, as was put to Mr. Ali Brigham, you must have read hundreds, if not thousands, of sets of company accounts. Yes, I have. Yes. Then you understand what you're looking for. You understand.
Yeah. No, I mean, I understand that. I also thought there was a particular piece of evidence which, at the moment, I have to say I'm disposed to accept, which was that Mr. Malaika, I think, was asked about prospectus and so forth, and he said, yes, I've read lots of prospectuses, but I don't think I've read one from beginning to end. I paraphrase what his evidence was, but
yes, indeed. If you are a sophisticated and experienced investor, you go first to the balance sheet and to the profit and loss count, and you're looking there to see if there are any impairments. You cannot say, as an authorised firm, oh yes, but if you dug into the notes at the back of the accounts, you would have seen that there had been some defaults, etc. If those defaults ought properly, if you were being clear, fair and not misleading, to have been reflected impairments in the primary records, if you like, of the balance sheet and the profit and loss account, you cannot rely on those if you have not produced a true and fair view of the financial circumstances of the fund, which should have been reflected in that. So if you're saying, on one hand, you're an experienced investor.
yeah, no, I've got one.
They read it in an experienced way.
At some point, we ought to take a mid-morning break.
I don't know what's the time. Would this be a good time?
Well, it's 15:15, so
Yes,
we're
so-
about halfway through.
Yeah.
We'll take 10 minutes.
I'm grateful. Yes, you're. Your Honour, perhaps I could pass up this spreadsheet I was talking about.
Thank you.
Could I pass that to His Honour, please?
Thank you very much. Is this going to go on the electronic?
I think that it hasn't gone yet, but I think that is the plan. Yes, yes.
Yeah.
And this is the sort of analysis of the, effectively, I think, primarily the volatility of the of what essentially an analysis of the RASMALA Trade Finance Fund in the middle, along with other low risk investments. Primarily in the middle, there's LIBOR 3 months. And then there's also Vanguard Short-Term Treasury Index institutional shares, and obviously Mr. Al Ibrahim's evidence was that LIBOR is the benchmark of low risk. And you see that RASMALA Trade Finance Fund, on an analysis of that they carried out prior to investing, conformed with the representations.
So sorry, what's the source of these figures?
I think these are taken from the fact sheets and the figures that were provided to ALAWWAL, fact sheet and the presentation and the RFP.
I mean, I haven't focused on these, but the Vanguard funds which are referred to, they're on the fact sheets, are they?
I don't believe so. I think those are what they have compared them with, etc. So this was a comparison that has been prepared just to demonstrate.
Sorry, prepared by whom?
It's been prepared by Mr. Al Ibrahim.
At the time?
No, this has been prepared so that in response to your questions to us, which was how do we?
So this is taking some funds. And
yes. And it's taking the funds and looking at the volatility.
And what's the maximum drawdown? I mean, I can see the standard deviation. What's the maximum drawdown?
Well, what I think is the suggestion is that in terms of drawdown, there had been no drawdown on the RASMALA fund, according to the information that was provided, which reinforced the view that it was a low risk, low volatility investment. So what essentially this is intended to demonstrate is, one, is when we're talking about low risk, what is the benchmark of low risk? Well, the benchmark is LIBOR 3 months and that sort of order. Whilst we don't accept that that line in the PowerPoint presentation which said that the fund was targeting LIBOR plus 5%, what we are saying is all the representations that were made were that the fund was low risk.
Sorry, why don't you accept that?
I don't accept that necessarily means that was a clear indication that the fund was high risk. That was,
sorry.
Yeah,
but the factual element of the target was accepted.
Yes, I have no reason to doubt that may have been the case, although the actual returns that were being achieved were nothing like that. So when one of the discussions that took place at the 23rd of January meeting was why the fund was achieving much lower returns than sort of comparable investments of comparable risk might have been regarded. And the answer to that was, well, because of all the risk mitigation measures, we refused to take risks. And so essentially it was reinforcing all the time. But their analysis of the volatility had basically shown yes, in terms of what's happened in the past, certainly in terms of the figures they've been provided in the RFP, the presentation of the fact sheet, that came out as shown here. So it was in line with a sort of LIBOR 3 months investment.
Yeah, okay.
So I think I was dealing with this point about failure to challenge the evidence of Mr. Al-Ibrahim and Mr. Malaika. Now, the evidence, I think it's just worth looking at the particular paragraphs that were not challenged. And in terms of Mr. Al-Ibrahim, it's paragraph 15 of his witness statement, which Your Honour will find Bundle B, tab 1, page 17, I think it is. No, it's not. Paragraph 15 is page 7, sorry. Page 7. So he says there at the beginning of the meeting, I informed Mr. Zografos that ALAWWAL was planning to launch its own multi-asset fund and trade finance fund, and that investments received into ALAWWAL's funds would be used to invest in other trade finance funds. As set out in ALAWWAL's fund presentation, I told him that it was a requirement for us that new managers and new funds fit the investment mandate of ALAWWAL's funds, which included aligning with risk profile of ALAWWAL's funds. With that in mind, I told Mr. Zografos that ALAWWAL was seeking to invest in Sharia-compliant investments with a low risk profile. Now, if that is not challenged, as it wasn't during cross-examination, then in my submission, the court must proceed on the basis that that is correct, that evidence is correct, and Ribble cannot present a case that is inconsistent with that. As far as Mr. Malaika is concerned, it was paragraph 23 of his evidence, which is Bundle B, tab 2, page 8. And this is extremely important in terms of what happened at the meeting on the 6th of February, because he says, during the course of the meeting, I made it clear that ALAWWAL was seeking to invest in Sharia-compliant investments with a low risk profile, and I made specific inquiries about the existence of any defaults or legal issues that could affect the performance of the fund, invited Ribble to share information regarding deals that had gone bad and the lessons learned from such deals. That was not challenged. If, as must be the case, that evidence is accepted and continues, then that means that everyone sitting in the 6th of February meeting knew that ALAWWAL was only interested in a low-risk profile investment. And it also means that specific questions were asked about defaults, and that those questions must have been answered. I mean, if ALAWWAL, Mr. Malaika, had asked the question, tell me about defaults or legal issues that could affect the performance of the fund, then clearly there was an obligation on those present to answer that question truthfully. Secondly, that explains the representations that were made. The position that is adopted on the evidence by Mr. Swats and Mr. Bitcon was, although they can't remember what happened, they say very few questions were asked, or no questions were asked, which I've already said is given the nature of Mr. Malaika, as Your Honour observed in the witness box. But as his evidence must be accepted on that point because it was not challenged, he did ask those questions. He did tell them he was looking for a low-risk profile investments. He asked questions about defaults, so there must have been answers to those questions. In the absence of any evidence to the contrary, and on the basis of adverse inferences being drawn, then Mr. Malaika's evidence must be correct in my submission. That the representations that he says were made were in fact made. Now, although Mr. Malaika was not challenged and Mr. Al-Ibrahim was not challenged, certainly as far as Mr. Malaika, well, both of them, their evidence, their case, was put to Mr. Swats, and I deal with this and give the references at paragraph 33 of my note. That this case was actually put to Mr. Swats, and whilst that's not absolutely necessary, it's clear that they were given an opportunity to put their case, although Mr. Malaika was not challenged and Mr. Al-Ibrahim was not challenged. Now this is in my submission key to the disposal of a number of important issues in these proceedings. If the ALAWWAL investment objectives were explained to Mr. Zographos, it is much more likely that he stated on the 14th and 23rd of November that an investment in the fund was a suitable investment for ALAWWAL, having regard to their investment objectives. Furthermore, there can be no innocent explanation for Mr. Zographos informing Mrs. Vyas on the 19th of February that ALAWWAL had a high risk tolerance. Everyone attending the 6th of February meeting must necessarily have known that ALAWWAL was seeking investments with a low risk profile, and would have known that investment in the fund was not a suitable investment for ALAWWAL. Mr. Malaika's questions, which must necessarily be found to have been asked, gave rise to an obligation at the 6th of February meeting to disclose the defaults to the value of $35 million that had been incurred at that time. And furthermore, in those circumstances where those questions were asked, there must have been a response to those questions. And it's therefore far more likely that the alleged oral representations in relation to defaults and other representations were made at that meeting. I'm going to move on and just look at those meetings now and how, in my submission, Your Honour should deal with them. As far as the 14th of November meeting is concerned, obviously Mr. Al-Ibrahim was the only witness who gave evidence of what was said. Mr. Zographos wasn't called. On the basis of that, Mr. Al-Ibrahim's evidence, the failure to challenge paragraph 15 of his witness statement, and the adverse inferences to be drawn from the failure to call Mr. Zographos, my submission is that the court should conclude that Mr. Al-Ibrahim explained ALAWWAL's investment objectives to Mr. Zographos on the 14th, and that Mr. Zographos made the 14th of November representations. Now, I think it's helpful at this stage just to look at those representations as we move through, and Your Honour will find them at paragraph 14 of the amended particulars of claim at Bundle A, tab 2, starting at page 4. Excuse me. I think it is also relevant here, whilst we look at that, to understand that at this meeting, Mr. Zographos would have known that the fund had incurred defaults of $35 million. That was clear from the investment management report that was looked at in the meeting in August, all of this being behind Bundle F, tab 28. So the allegation is that he said at this meeting that the fund was very selective in terms of clients it transacted with and dealt only with reputable clients with long track records. Now that's sort of reminiscent of what has been said in the RFP and the presentation, so it's hardly surprising that he said it. 2, that due to the fund's very strict lending policy and many layers of guarantees and risk mitigation measures that it applies to a transaction, there is a 0% possibility of making losses. I think we had an exchange about this when I was opening the case, and Your Honour said, well, that can't be taken literally because nothing is 0%. No investment can be that, and I acknowledge that that's obviously right. One has to look at the context in which this is being said. That context is that Mr. Zographos knew that the fund had lost $35 million. The context is it must be accepted as a representation that the fund was low risk in the ways that that is understood by reference to volatility, etc. And that was clearly a misrepresentation given what he knew. He could not have said the fund was low risk. He could not have said, he couldn't have said it anyway on Ribble's case, but knowing that $35 million of defaults were sitting there. And also that the fund met the ALAWWAL investment objectives, which is another way of saying it is low risk and Sharia compliant. So my submission is that Your Honour should find that those representations were made. Moving on to the 23rd of January meeting, the only witness again able to give evidence on what was said is Mr. Ali Ibrahim. Mr. Zographos and Mr. Lomonaco have not been called. This also, though, is the only meeting in respect of which there were actually minutes. And those minutes, 23rd of January minutes, tend to confirm that the 23rd of January representations were made and that ALAWWAL understood that investment in the fund was low risk. I don't know if Your Lordship, Your Honour, will be assisted by going to look at those minutes again.
In your hands.
Let's just look at them. I think it's tab 140. In the bundle F.
Yeah.
So on page 1 we have all the effectively the minutes aspect of it, of details of what was actually said. Returns of all trading funds were reviewed. Risk rates for each fund standard deviation were reviewed and compared, reference to the Sharpe ratio. Representatives of the RASMALA fund were asked about the reasons why the RASMALA fund achieved investments returns which were below the average for the fund. And then Demetrius explained that low investment returns were attributed to several reasons, the most prominent of which were funds managers reservationing, executing and financing deals with parties that do not have a good reputation. So this carries on this representations that have been made frequently about how selective it was with clients, keen to take high and multiple guarantees in line with the fund's strict standards. Then over the page, high operating costs due to the keenness of the fund manager to appoint independent and specialised companies. So it was explaining that the slightly lower returns that were being achieved were all due to the fact that it was so much more stringent on its risk mitigation measures, including appointing third-party advisors. And then finally, at 5, Demetrius asserted that the fact of RASMALA fund achieving the lowest risk margin is evidence of the fund's low risk. That confirms the pleaded case and the pleaded representations. It confirms that Mr. Zographos was repeatedly referring to this fund being low risk. And we see that then flow through into the recommendation that is made to the Business Development Committee of ALAWWAL. And it looks at the bottom, we have point 6, based on RASMALA achieving the lowest risk rate compared to the rest of the funds. And 9, based on ALAWWAL's policy of preferring risk avoidance over returns. So in other words, it was prepared to sacrifice returns if it was able to get a lower risk. It made that the recommendation of investing in the ALAWWAL fund. And we've seen, you can see in the evidence that flows through into the minutes of the Business Development Committee meetings, where they have made a decision essentially on an understanding that this was a low-risk fund. Now, if we then go and look at what the alleged representations are on the 23rd of January, paragraph 25 of the amended particulars of claim at page, bundle A, tab 2, page 9. And these alleged representations conform with what the minutes say. So, one, low returns made by the fund were a result of the fund dealing only with reputable clients and insisting on a variety of guarantors and risk mitigation measures. The fund's competitors took risks in order to achieve higher returns. The fund had a dedicated team to each transaction. The fund had specialist representatives in a number of countries to detect fraud. And then again, the investment in the fund was appropriate having regard to ALAWWAL's investment objectives. Now, based on Mr. Ali Ibrahim's evidence, which is corroborated by the minutes, there is no basis at all for not accepting that the minutes are an accurate record of what was said at that meeting, albeit a summary. And the adverse inferences to be drawn from not calling Mr. Zographos or Laminoko. In my submission, Your Honour should conclude that Mr. Zographos made the 23rd of January representations as pleaded at paragraph 25 that we've just looked at. Moving on to the 6th of February meeting. The 6th of February meeting was attended by inter alios Mr. Malaika, Mr. Swats and Mr. Bitcon. And of those witnesses, only Mr. Malaika professed to have any recollection of what was said and done at the meeting. Now, at that time of that meeting, it is, in my submission, relevant that there was this default of approximately $35 million. And it is also relevant that there had been this reduction in assets under management of $50 million, and that there was evidence, just for Your Honour's note, that evidence is in the minutes to be found at F175, page 9, minutes of a board meeting, that there were liquidity problems as a consequence of the reduction in the assets under management. Now, both Mr. Swats and Mr. Bitcon denied that there were liquidity issues, but there is reference to it in the minutes. And indeed, what those minutes say is that they were relying on $7 million, which were expected to come at the end of February, and further investments in April to provide liquidity for any redemptions in March. Now, I've dealt with the fact that Mr. Malaika was not challenged on paragraph 23 of his evidence, and what that means in terms of Your Honour's findings on this, on what happened at the meeting. It's important there that Mr. Bitcon's evidence was that he understood that the 6th of February meeting was part of ALAWWAL's due diligence, and that he was expecting them to ask questions. If one looks at the transcript for day 4, what did I say? It's page 70 going over to 71, page 70, line 15.
Are you using the 4-page ones? Have you got the page around?
I'm using the 4-page ones. The PDFs is what I'm looking at. I think the page numbering is the same, but
so page 19 of the PDF.
I can't see that numbering. Hang on, it's at the top. I apologise. I can't. I've just got this on my screen. I can't see the any other numbering other than the numbering of the individual pages, 4 to a page. Sorry. So yes, I don't know. Has Your Honour got to page 70?
Well, page 70 of the 4-page number. What's the point you're looking at?
So starting at line 15, it says.
Looking at paragraph 6.1.
Yes, yes. So I'm looking at paragraph 6.1 of your witness statement. I think you're still in that document. The point I was just going to make to you is that the purpose of this meeting was part of the due diligence that ALAWWAL was carrying out, and they were coming there to ask you questions and understand the position of the fund.
Mr. Bitcon said, that's right, that was my understanding. And so you were expecting him to ask you questions about things like defaults, etc., weren't you? And he said, we have a standard presentation that we go through. Investors typically would ask questions along the way, and that's what happened, wasn't it? That is, I can't remember the exact details, but yes, we would have gone through the presentation with ALAWWAL's team. So,
unlike Mr. Swartz, whose evidence tended to be that this meeting, as far as he was concerned, was just to run through a presentation, no questions to be asked, etc., etc., Mr. Bitcon was clear that he did understand that this was part of a due diligence process, and he did understand that questions were going to be asked. Now, he couldn't remember the asking of questions or any answers given, but he did understand that that was what was intended to take place. I think I would refer, Your Honour, I don't think we need to go there. Well, maybe since we've opened it now. Page 72, line 1 to 17, is
deals with this. So it begins there, top of page
72.
Mr. Malaika told you that they were looking to invest in Sharia-compliant investments with a low-risk profile, didn't he? Now, I don't specifically remember that because I don't remember the meeting. So you don't really have a recollection of what, but no, all I know is we went through the presentation and specific discussions I cannot confirm or deny.
So he was quite clear that all he could remember was that he went through the presentation, and he can't confirm or deny any specific discussions that took place. Mr. Swartz's position was somewhat untenable. He said he couldn't remember what happened, but was trying to argue effectively that because he can't recall questions being asked, or he can't recall specific things being said, they didn't happen. That, in my submission, is an obviously untenable position to adopt. It's interesting that despite being an authorised firm and Mr. Bitcon understanding that this was part of the due diligence process, no minutes of this meeting were taken by Ribble, and there's no record of this meeting in their offices. So on the basis of Mr. Malaika's evidence, the failure to challenge paragraph 23, the fact that Mr. Swartz and Mr. Bitcon have no recollection, and the adverse inferences I'm urging Your Honour to draw, my submission is that you should conclude that the ALAWWAL investment objectives were explained, that questions about defaults were asked, and that the representations that are pleaded at paragraph 26 of the particulars of claim were actually made. If we could go to paragraph 26 of the particulars of claim, that's bundle A, tab 2, page 9. And they're set out there. So the first one is that as at the date of the meeting, there were no legal issues or defaults that could affect the performance of the fund. The fund's investments were well diversified in terms of geography, sector, economy. All of the risk mitigation measures explained in the documents that had been provided were implemented for each transaction, and the funds were adequately covered at all stages. I think during the course of his evidence, Mr. Malaika sort of tried to explain that a little bit, that in the various tables in the RFP and in the presentation, there were specific risks set out. So there was the credit risk, there was the fraud risk, there was different categories, and then they had a number of bullet points under each of those risk categories. And I think what he was saying was he believed that what they were telling him was that certain of the measures against each of those specific risks would be used and would be multi-layered in order to mitigate risk.
In respect of every transaction, a 20% margin was obtained up front. That again is something that is repeated in the RFP and the presentation. There were only a few scattered cases of default involving small counterparties. These cases were all settled satisfactorily due to robust multi-layered security mechanisms. The borrowers were obliged to provide a 20% margin, thereby limiting the fund's exposure to 80%, covering adverse price movements, etc. And then at 6, no deal will be undertaken by the fund without solid guarantees covering 100% of the value. Then 7, if any default occurred, the fund would make a provision against the exposed amount until it liquidated the underlying guarantees. And due to the fund's strict investment strategy, there were no recorded defaults in the fund. There had been some delays in payments, but these were usually paid in the end to avoid the enforcement of guarantees. My submission is that Your Honour should find that those representations were made. Then the final meeting is the 25th of February meeting, and again, the only witness before the court able to give any evidence of what happened there was Mr. Al-Ibrahim, Mr. Zografos and Mr. Aker not being called. So we say that on the basis of Mr. Al-Ibrahim's evidence and the adverse inferences to be drawn from the failure to call those two witnesses, the court should conclude that Mr. Zografos did make the representations pleaded at paragraph 27. If we could go and just look at those, I would say it is relevant here that there are echoes of what has been said at the meeting on the 6th of February and also what was said on the 14th of November. So, of the transaction, multiple guarantees were taken against borrowers, and the nature of the business model of the fund prevented unit holders from suffering losses. All of the transactions had to be backed by an underlying purchase assets, which must be commodities, goods or receivables that can be monetized in the downside. The protection of the investors in the fund is enhanced through risk mitigation measures such as over-collateralization. And then this particularly 4 is effectively a repeat of what was said on the 6th of February. There had been no defaults in the fund, and in the case of delayed payments, the fund had the right and capability to enforce some or all of its guarantees, which were taken to cover 100% of the fund provided. So we have a sort of a little bit of an overlap between what is said in one meeting and what is said in the other, which makes it, in my submission, more likely that these things were repeated. Now, dealing with the 2017 accounts, as I've said in my sort of introduction to these submissions, RIBL has sought to rely on those, firstly as having made the relevant disclosure of the financial position at the time, and secondly, for effectively the basis for denying what was said on the 6th, what is alleged to have been said at the 6th of February meeting. The key provisions there are notes 3 and 16 to the 2017 accounts. And as we've already discussed, Mr. Al-Ibrahim and Mr. Malaika said they didn't read those notes. The key question is whether those accounts present a true and fair view of the financial circumstances of the fund, and whether, in particular, whether they deal properly with the defaults that existed as a result of Mettrade, defaults by Mettrade and by Farlin. My submission is that there was never given any valid explanation as to why an impairment had not been taken in relation to Mettrade. It had in its there had been a default, a debt of 10.5 million almost in the 2016 accounts. During the course of a year, that had increased to 14,372,000. Litigation was on foot against the principal debtor and also the guarantor in 2 jurisdictions, in the UAE and also in India.
whilst it's accepted that there was credit insurance in place, and credit insurance did indeed pay up to the tune of about 10 million, clearly the recovery of the balance was inherently uncertain, because litigation is inherently uncertain. Now, I think this was Mr. Bitcon's evidence, and it is clear in any event from the note 2 to the accounts that this assessment of impairment was done under IAS 39 impairment model and not IFRS 9. Now, I've dealt with this at paragraph 34 of my notes. What is clear is under IAS 39 there is a loss event. So the first question is, was there a loss event here? That's what triggers the model and the progress through that model. And yes, there was, because there was a failure, a default in paying sums that were due on a particular date. And the loss event can relate merely to the non-payment of interest or to the non-payment of the principal. This is a Murabaha contract, so there was a non-payment of sums that were due, which was a principal sum under that. The next step, if there is a loss event, is the measurement of that impairment on the basis of discounted future cash flows. And I just explained in my note that, you know, with Islamic finance that uses Islamic benchmarks rather than effective interest rates. Now, the judgment ought to have been made, as hindsight has proven, that the recovery of these sums was inherently uncertain. They'd been outstanding for over a year. Litigation was necessary. There was going to be no voluntary payment. So the uncertainty of actually obtaining a judgment, more particularly of enforcing it, should have been factored in there, and there should clearly have been an impairment taken. So as far as the 2017, as far as Mettrade is concerned, the accounts were unreliable, they were misleading. And they also prevented an experienced reader from those accounts from moving through them from the impairment to understanding exactly what had happened. Now, as far as the note 16 to the accounts is concerned, dealing with the default by filing, my submission is that it is also misleading. I think it might be helpful just to have that in front of us. If Your Honour could go to tab 28 in the F bundle.
Yep.
And I think it's the note is at page 63. Now, we say that that note there is not accurate and is misleading. And I set out paragraph 56 of my outline submissions, the three reasons why we say that that note is misleading. And it's primarily the second part of it, where it says that it's from the fourth contract of US dollars 4,223,000 remains unpaid. The due date for the payment of this contract is 29th of March. Directors of the fund are in discussion. This is key. The directors of the fund are in discussion with filing who is committed to repayment of the outstanding amount together with delayed charges, subject to the reaching agreement with the to finance future arrangements. So the outstanding sum owed by Farlin as at the 27th of September was not 4,223,000, but 19,850,000 odd. That, in my submission, ought to have been included in the note. It is unclear whether there were continuing discussions as at the 27th of September, but if there were, any such discussions would not have related to the repayment of 4,223,000. They would have related to the outstanding sum of 19,850,000. But most particularly, it is grossly misleading to say that on the 27th of September 2018, Farlin was committed to the repayment of the outstanding sum of 4,223,000 in circumstance which became due on the 29th of March, in circumstances where it had further defaulted in respect of another 15 million and clearly had no intention of paying any of them. So that note is clearly misleading, and the question arises because this is an adjusting entry, it's not a non-adjusting entry. It relates to a state of affairs, i.e. a debt that existed at the time of, as at the 31st of December 2017, as to whether there should also have been an impairment of that debt as a result of what has happened subsequently. An impairment of, in respect of the 4 million.
I mean, how does this quite work in your case? You've got a series of, this starts off from representations said to have been made, that there were only a few small scattered defaults. And the response to that is a denial or a non-admission that that was said, a statement that you'd got the accounts, and that if you looked at the notes to the accounts, you could see that the representation wouldn't have been made, together with oral evidence from the defendant's witnesses, that if there had been questions about defaults, they'd have gone through it carefully, etc. So that's the context for this. Now, your client's evidence is, yes, we did have the 2017 accounts. We didn't look at these notes, we just looked to see whether there was impairment. And therefore, in a sense, we didn't appreciate that there were any defaults at all. That's the battleground in relation to this. Now, there are several points, various points, it seems to me, that there's something of a tension in the defendant's case as to whether there were defaults which are disclosed by the 2017 accounts, or rather there weren't defaults but just non-payments. Leave that to one side. But in any event, it seems to me that the 2017 accounts refer to a balance sheet position which is over 13 months out of date by the time of February of 2019, and where even the post-balance sheet events, i.e. between the 31st of December 2017 and September of 2018, are 4 months old. And it seems to me that if the statements were made, and if your clients didn't read these notes, I'm not sure it matters all that much as to whether or not impairment should not be made 2017 accounts, because frankly by 2019 the matters have moved on, and it's pretty plain that there were defaults which, it seems to me at the moment, were material.
Yes.
So that's a long way of saying, do I actually need to come to any view as to whether or not the directors, and of necessity KPMG, were correct in their treatment of the position as at the 31st of December 2017, having regard to the fact the accounts were signed off in September of 2019?
I think Your Honour is correct. If Your Honour finds that those representations, the pleaded representations, were made on the 6th of February and that they were false, that therefore you don't really have to bother your head about the rights and wrongs of the 2017 accounts. I accept that's right. The reason they are important, however, is perhaps for the process by which you get there to that decision. Ribble prays in aid these accounts and says effectively, look, we disclosed our most recent accounts. They gave a true and fair view of the account, of the financial circumstances of the fund as at that date, and you know, we were being honest and frank, and you can accept, because we disclosed that, you can accept that we wouldn't have said something that was inconsistent with that at the meeting. Now, if on the other hand, when your Honour looks at those accounts, you see, firstly, that actually these accounts are a little bit misleading. They're not properly prepared. There clearly should have been impairments in there, both in relation to Farley and Metro.
I'm just pausing there.
Yeah.
I'm not saying that it wouldn't be possible for me to find that there should have been disclosure of impairments. Having said that, it might be said to be something of a bold finding, absent accountancy advice.
Yes.
I mean, at the moment, it does seem to me that well, it seems to me that KPMG's willingness to accept the position in the 2017 accounts, and actually, from what I've seen, their willingness to accept the position in the 2018 and indeed, I think 2019, or I might have got that wrong, but certainly the 2018 accounts, seems a little bit surprising. But it is still a fairly bold proposition for me to say that there's been incorrect treatment of accounts without accountancy evidence to that effect.
I think what I entirely see that. I think what Your Honour is able to say, that it is arguable, strongly arguable, that there ought to have been an impairment, but you haven't had the benefit of any expert accountancy evidence on that issue. But you are entitled to take cognizance of the fact that there's a strange parting of the ways with PwC. Actually, after the date on which these accounts should have been filed with CIMA, with the Cayman Islands Monetary Authority. So we had that extraordinary event that KPMG were engaged by an engagement.
Yeah, no, well, I've got your points.
Yeah.
That
So
the natural inference of all of this is that there was a row between PwC and the directors, although that's not accepted. And I've got your points that although it was suggested that KPMG had been approached before the time when the account should have been filed. I mean, the converse of that is that if in February of 2019 you're being presented with accounts to the end of 2017, which is 13 months before, and you look and see these accounts are filed late, that could be said to raise some questions of itself to experienced investors of the sort your client is, to which your response is probably, well, it may have done, it may not have done, it didn't, and it's irrelevant to the representation.
yeah, I think it's less obvious that you would have seen from the accounts that they had been filed late, because that really entails an understanding of when CIMA would have required them to be filed.
Yeah.
You know, if you've got accounts filed signed off in September in relation to a financial year ending on the previous 31st of September.
Perhaps a better point is, well, if you're looking at the position on the accounts, you're already a month and a half post year end, and it might incline you to say, well, that's all very well, but what's the position as at the end of 2018? Now, probably very unlikely that you'll have audited accounts by then, but you will have management accounts.
I mean, yes, they could have asked for management accounts, I accept that entirely, but what Mr. Malaika says, sorry, I keep getting it the wrong way around, Malaika says, is I asked them about defaults. I asked them about the financial circumstances of the fund. I asked them if there were any defaults that would affect the performance of the fund. Those are the specific questions he asked. So,
and so just while we're on this, in terms of the asset value of the fund, and this arises out of the questions I raised on Friday afternoon, but does the fund provide monthly asset statements?
I'm going to take instruction on that because I don't know off the top of my head what the answer is. I think the answer is, I'm sorry, we can find out, but I don't know the answer.
Well, no, I mean, it's simply that in a sense, it may be that in a sense that the management view of matters is provided by monthly statements of the fund, if that's what's happening anyway.
Yeah. But I suppose the second question is if it did produce monthly asset, net asset valuations of the fund, whether those were shared with a prospective investor.
Well, I agree, and I mean, in the documents which I have got, there are fact sheets which appear to be being presented on a monthly basis. There's a September fact sheet, there's an October fact sheet, etc.
And essentially those fact sheets, I think, were one of the bases for the preparation of the spreadsheet that I've passed up to Your Honour.
Well, I mean, what it looks as if those fact sheets do is they simply update it on a monthly basis as to what's happened to the asset value.
Yes. Right. I don't know. Yes. So I suppose that the point I'm making to Your Honour is taking into account change of auditors, the view taken by the directors as evidenced in the failure to take impairments, but also interestingly the evidence that came out of from Mr. Swats and Mr. Bitcon regarding whether there should have been impairments. I think Mr. Swats was all at sea and wasn't able to assist at all. Mr. Bitcon was very tenacious in the view that he took, although he struggled a little bit, I have to say, regarding net trade, when it was suggested to him that this was all inherently uncertain. And I think Your Honour actually took part in that exchange.
I mean, for what it's worth, and it was partly by reference not to the 2017 accounts, but to the subsequent accounts when ISFR 9 had come in, it seemed to me that it was quite difficult to square the treatment in the accounts with the actual provisions as to late payment and so forth. Now, again, that comes back to this question as to the relevance of all of this and as to whether a finding, whether a finding that the accounts, as at the dates they were filed, was in fact misleading is either open to me or necessary or appropriate. But anyway,
I think what finding would be open to you on the basis of the evidence is that there was an unrealistic optimism about recoveries, as expressed by Mr. Bitcon, and a marked reluctance to record impairments in the fund.
well, I mean, just on that front, as I've already observed, I mean, the effect of impairments would, as I understand it, have been to flow through fairly directly into showing a deprovement or showing a adverse position on the asset value on a monthly basis. That's how I presently understand the effect of doing so.
Yeah.
And also, given the relatively small profits being showed by this fund, we don't need much of an impairment to start getting to an annual loss.
Indeed. And I mean, that would have been evident to the RASMALA team as they sat in the meeting on the 6th of February, whatever view one takes about the what was said. Put that on one side for a moment. Sitting there with $35 million worth of losses, it must have been evident that there's a massive loss for the purposes of the fund. Had a massive implication. You know, it was essentially 10% of the value, in excess of 10% of the value of the fund.
While we're on it, one of the other questions which I raised on Friday afternoon is as to whether there was any. I mean, I know that it is the defendant's case that losses were caused by COVID, and I know that you've identified several times the position that you say that had been got to by February 2019 in relation to 35 million of effectively unrealised losses. And just to be clear about the effect of that, given the basis, as I understand it, of investments, what that means is that when you're putting in your 5.5 million and your 1.3 million of these others things, you're effectively paying for assets which on your case aren't there or shouldn't be there. So it does have a significant effect. But is there any statement as to the causes of the losses which have occurred other than those which are contained in the 2020 and 2021 accounts?
No, the only things you can do is glean, certainly in relation to the period prior to the investment. So what I have done is
No, I'm sorry, that wasn't my question.
Right.
They've got a positive case, effectively, that this is all very well, but you invested in this fund, you were jolly unlucky, you invested in 2019 and the loss has been caused by COVID, I summarise. Your response to that is, well, we concede that 35 million of those have got nothing to do with COVID, and you put that in various different ways. But my question is, in relation to the actual losses which were suffered, have we got any statement of how these losses occurred, other than those which are set out in, I think, first of all, the 2020 and then the 2021 accounts?
Your Honour will remember the PTR. Remember that one of the disclosures that we wanted.
Yeah, you wanted precisely what's happened, but well, I mean, the reason I ask is you've obviously got those accounts, which I assume your clients have got.
Yes.
But you would ordinarily expect statements as to how how a fund's lost half its value to be identified in public documents. And you also made the point that one of the grounds of winding up and has the fund actually been wound up?
To my knowledge, no, not yet.
But it's one of the grounds of the petition.
The petition was presented, as I understand it, last September.
Yeah.
It's just an equitable petition.
Yeah, and
so
you've made the point that one of the grounds of it being wound up is the lack of transparency.
Yes, and so no doubt it will come on for a hearing at some point, but it's obviously going to be a fairly substantial piece of litigation over this particular winding up petition.
But I mean, in one sense, I question whether this matters, because subject to the point about loss of opportunity, which I'm going to ask you about in a minute, because I want to understand the basis upon which you put a positive case that there would have been investment in one fund as opposed to the case which the defendants put forward as to an alternative fund. But subject to that, as I understand it, if the representations are made out, there is no issue as to the loss you've actually made. And so I wonder whether or not it actually matters as to this positive case. But at the moment, it seems to me that probably the burden of a positive case that losses were caused by COVID lies upon the defendants.
Indeed, and if we were misled into, as your Honour has implied, if we're misled into investing in the fund and happen to lose money on that, it doesn't really much matter what the cause of that loss is.
One can imagine an alternative case where it might be said, look, the extent of your loss is only, the amount by which, as it were, the investment is worth less because of the misrepresentations. But that's not being put forward in this case, and one assumes it's not being put forward because effectively there was no opportunity for you to get out in knowledge of the true position. But anyway, it's not an issue I have to deal with.
No, it's not an issue. It's not an issue that we can really properly. I think
the answer is it's irrelevant because, as I understand it, if the misrepresentations were made, then, as I say, subject to the point about consequential loss, loss of opportunity, the amount of the loss is agreed.
I think that the explanation provided for the losses being COVID goes to this transparency issue and is sort of infective of other issues, in that what we would say is that consistently there has been a lack of transparency in relation to the management of the fund, that they made these misrepresentations, their accounts are misleading, and when it got to the actual closure down of the fund and the lack of redemptions, as it were, they came out with a story that it was all down to COVID, which was all very convenient, but isn't truthful. And so what we say is that it actually evidences a failure to be transparent, to be frank, with investors throughout the whole sorry procedure.
I mean, a more charitable view would be that COVID is the occasion of some of these losses rather than the cause, and that one of the consequences of an economic recession or tide going out is that you get left with a lot of stranded whales around the place. But anyway, I'm not sure it matters.
No, I agree with that. I think the importance of it may be more that it's obvious that to a certain extent the fund was not being transparent about the causes of the losses. And it may be that COVID did cause some small losses, but the substantial amount of them had all been incurred before we even got to investing, or a very large chunk of them in any event.
Now, while we're dealing with points that are put and were not put, you plainly put to the defendant's witnesses that on the occasions when they were actually present, representations were made. And I've got your case, obviously, that in relation to 3 of the occasions, you couldn't put that to anyone because there wasn't anyone there to make it. And you've also got the point, or made the point, that in relation to the written documents upon which you rely, the RFP and the PowerPoint presentation, it's obviously accepted that they say what they say. It's a question of what the consequences of that are. You didn't, I think, put any case about motivation. I mean, you made the point that at the time the representations were made, there was a need for money to replace the 50 million which had been taken out. And well, you made that point, but you didn't suggest to either of the defendant's witnesses that they were, and indeed you haven't got a case in fraud, so in a sense one wouldn't expect it, but that you know, they deliberately didn't provide information or anything of that nature.
What yes, as Your Honour says, we have not pleaded fraud.
No.
And we don't need to establish fraud.
No.
And so I think it probably would be inappropriate.
No, but my question, I think, is how does that then deal with motivation? So far
Well, I
as
think
the
I
defendants-
I did explore motivation because I did refer to the fact that there were serious liquidity problems.
You did.
And I referred to the fact that suggested that 7 million referred to in the minutes as being likely to resolve.
You put both of those cases,
Yes.
but I mean, in a sense, my question is, so what? You put those. Where does that lead?
Well, I suppose I think, and the point I put to them, I think I put it in terms, if not implicitly, was that these monies that were coming from ALAWWAL were very important to the fund, and they clearly needed them. And then otherwise I just put to them the case that these representations were made. So I agree.
You did also put a case based upon the relevant rule. You know, I forget what it was, but failing to
Clear, fair, and not misleading.
Yeah, be fair and not misleading, and so
Yes.
forth. But in a sense, that's an objective test, isn't it? It's not to do with motivation.
No, it is. I mean, effectively, it sort of dovetails with the statutory duty of care, which is a requirement that they should use reasonable care and diligence in everything they do as an authorised firm. And so that's part of our case, it's part of our pleading case.
In a sense, what comes out of what your case is this. As at February 2019, there were defaults on your case, which were significant,
Yes.
and they, I think, ran to something like 10% of the fund or thereabouts. The consequence of those defaults would have themselves been a significant deterioration in the asset value put forward on a monthly basis. That would have had 2 consequences. The first is that anyone who had invested would have invested at a cheaper price, so you'd actually, you wouldn't have paid for assets which weren't there. But probably far more significantly is that everyone would have seen that this fund was suffering.
Yes.
And it was a fund where withdrawals could be made, and bluntly would probably have caused a loss on the fund.
Yes.
And that therefore, rather than investing in a fund which, certainly with hindsight, looks like a dog of a fund, it's not producing particularly good returns and it's losing money, people would have run from it, and they'd almost certainly have had to close withdrawals and so on for that. Now, that's the objective consequence of what you put.
Yes.
But, I mean, you didn't put any case that they knew and appreciated all of that at the time, and et cetera, et cetera. You simply as it were, laid it out and said, well, that's the objective consequence of what occurred.
Yeah. Well, yes, I put it to them. They'd lost 50 million of assets under value, and they had defaults of 35 million. They had serious liquidity issues. Implicitly, my submission on the basis of that and on the basis of the evidence, that this was a zombie fund. This fund was on the verge of falling over.
I think I called it a dog of a fund, but anyway.
Yeah, dog of a fund may be a better description. It was on the verge of falling over. It was only a matter of time. There was a hand-to-mouth existence there. Money's coming in from ALAWWAL. We're going to feed any redemptions that came out. It was almost becoming a Ponzi scheme. And so what eventually happened when it did fall over in 2020 was blamed on COVID, but it really was...
Yeah, well, I mean, I think the consequence of the points which you sought to establish is that almost certainly this fund would have experienced problems significantly sooner than it actually did. But anyway, that anyway, all right. Well, I mean, that's I think that's as far as probably take it.
I think, Your Honour, that's 12:31, so it's probably an appropriate juncture
yes,
to
you're
end.
presumably going to leave yourself some time for reply tomorrow, are you?
Yes, my own friend and I have spoken about this. I think...
Well, I mean, I suspect, I'm not trying to impose anything, but I suspect you could have a day, and it's up to you as to how much of it you use in opening and in your
Yes,
way of
I'm going to finish, I think, before close of play this afternoon.
Well, if you don't, you're going to be in problems about time allocation, I think.
Indeed. I think my learned friend has said, maybe he'll explain himself better than I can explain himself. He said a few things to me this
Well,
morning.
I mean, I'm not making a point to it. I mean, I assume you've discussed the timing and...
We have. I take what my learned friend has suggested to me is he may need half an hour, possibly a bit more for a reply.
But I mean, assume if that's the case, then it's going to come out of his time today.
I assume so, but what I have said to my learned friend, obviously I'll have to see how I go, but I will make sure that I'm trying to be done by 3:30 tomorrow, whatever happens. So that it does.
Well, I mean, that's generous, and you can come to any agreement you want between you. It does seem to me, and you know, obviously I've been making some interventions, but it does seem to me that in a case like this, on the whole, the closing time should be divided 50-50. In that for a person in the position of Mr. Adair, he's got a choice as to how much he leads now and how much he does in the way of reply. But that, as I say, having trailed my coat, it's ultimately up to the two of you.
Yes, quite sure.
Very good. Well, we'll come back just after 1:30. Yes, Mr. Adair.
Please, Your Honour, just finishing off, we were speaking briefly about losses before.
Yeah.
I just would like to give you a reference, if I may, which I didn't include in my note. Some significant amount of losses that we say were not attributable to COVID were incurred through the Tricon Forfeiting Fund, segregated e-share account. And I took one of the witnesses, Mr. Bitcon, to the accounts for that.
Yeah.
The reference is G3032.2. Those are the, and it's page 8 and page 24. Page 8 shows an impairment of a little over 17 million, and page 24 shows, or has a note which essentially says that the risks to the fund were not increased by COVID, and essentially says COVID wasn't the cause of these losses. Just for your note, and we say along with the large number of companies, the Tilia, Bonaire, Ocean South, Shavy Petroleum, Metrade, Farlin, Metal Masters, New Zone Intertrade, and the liquidation of UIL. These were all pre-COVID, and whilst those accounts I've taken to you are as at 31st of December 2020, the note it sort of effectively exonerates COVID, we submit. I now want to move on and talk about the terms of the contract between the parties. Now, paragraphs 8 and 49(3)(b) of the defence, Ribble pleads that by virtue of the alleged subscription agreement, the terms of the offering memorandum are incorporated into the terms upon which ALAWWAL subscribed for shares in the fund. Now, that is the only pleaded basis upon which the offering memorandum is said to be part of the terms of the subscriptions. During the course of the hearing and cross-examination, it appeared, Ribble seemed to be appearing more, asserting more generally that the offering memorandum constituted the terms on which the shares in the fund were acquired. As I say, their pleaded case is merely on the subscription agreement. But my submission, and I deal with this particularly at paragraph 62 of my outline submissions, is that simply doesn't work. It's not a tenable argument. And if we go to bundle F, tab 17, to look at the offering memorandum, and I think it is to page 20 of that document. It's the relevant page. And it's got a page that says summary of terms. And at the top there, the following sections summarise the terms governing an investment in a share class of the fund. A complete description of the terms of such investment is contained in the memorandum and articles of association and the material contracts, copies of which will be provided to the potential investors upon request. If any of the terms summarised herein are inconsistent with the terms of such documents shall control. Now, the summary of the terms is the pages that follow within this section Roman numerals 5, or section V, Roman numerals 5, and it is none of the provisions upon which Ribble are seeking to rely. It essentially, the terms are the memorandum and articles, which is the contract between a shareholder and the company and the other shareholders. And this provision makes absolutely clear that this is not a contractual document. It's not purporting to be a contractual document. It is merely summarising the contractual documents, which are the memorandum and articles, and they say the investment agreement and the administration agreement.
Who's this? Who, on behalf of whom, is this offering document provided?
Well, my understanding is it's presided by the fund.
So it's the fund setting out terms upon which it will issue shares to new investors.
Yes, and I think really what it is doing, and what this section deals with, and what obviously the memorandum and articles deal with, is the rights attached to those shares and the rights of shareholders. So it's nothing to do with the investment process, if you like. It has everything to do with corporate governance, effectively, in terms of what rights anyone acquiring shares would have. And how redemptions of those shares happen, and things like that. It doesn't actually deal at all with any sort of dividends. If one moves on to page 24 of the bundle, dividends, transfer of shares, the things that are typically dealt with in memorandums and articles, the rights, whether a shareholder has the rights to sell their shares to someone else and things like that, what they have to dividends. The only thing that might be said to touch upon the sort of matters that my learned friend is seeking to run is the duty of care indemnification. And all that is essentially saying, which was no doubt in the Articles of Association, is that the company will indemnify the directors, the administrator, and the investment manager. Those are common provisions in memorandums and articles, etc., subject to statutory control. So, no, this document is the company, the fund's document, and it's,
There's
sorry,
there's no sponsor of this.
no.
Yeah. Okay.
And it's really, I mean, I'll come on to that in a moment. It's one of the reasons which I say that the disclaimer that Ribble seeks to rely on in the offering memorandum has no effect. So this isn't a contractual document at all. By the subscription agreement, which we, I think, discussed in some detail on the opening, I won't go back to it in any detail, they seek to incorporate provisions of the offering memorandum into that agreement and to effectively have set out a number of basis clauses that we acknowledge this, we acknowledge that, etc., etc. But that our position is as set out in paragraph 27(4) to 10 of the reply, and we essentially say they had no authority to enter into that agreement on our behalf, and we're not bound by its terms. So that's our position. This offering memorandum isn't contractual. It doesn't. None of the provisions, if one can call it that, or none of the statements in it have any contractual effect, and it doesn't purport to be when you properly analyse it. Now, as far as the disclaimers are concerned, I deal with this in some detail at paragraphs 135 to 143 of my skeleton argument. Ribble seeks to rely on the disclaimers in the offering memorandum, the RFP and the PowerPoint. They've produced a very useful table which they set out all possible disclaimers in all possible documents. And what I was going to do, if Your Honour is happy with that, is to actually, rather than going into the documents, just use this, which has got the wording of them, and make submissions from that.
And sorry, what you look at? You're looking at the
I'm
annex
looking
to their
at the Annex B to my learned friend's skeleton argument.
Yeah.
I say straight off that we say that by virtue of Conduct of Business Rules 3.2.2, these various disclaimers cannot be relied on in relation to any breach of statutory duty, whether that duty is effectively the equivalent, statutory equivalent of negligence, or the duty to be clear, fair and not misleading, or specific provisions which I'll come on to under Article 56 of the Collective Investment Law regarding statements made in relation to the to acquisition of units or shares. So looking at the offering memorandum, and I think we're going to, if I could take you to, I think it is item 14 in Annex B to my learned friend's skeleton, and they set out, and Your Honour will remember this particular provision, which is pleaded in the...
No person has been authorised.
Yeah. And I mean, I made my submission at the outset. I won't labour them because I think Your Honour has them, but the final two lines of that are what is clear. It's no person is authorised to give information, and then at the bottom, if given, such information or representation must not be relied on as having been authorised by the fund. So it may exonerate the fund, but it has nothing to do with Ribble. The rest of the disclaimers, 15, 16, or 13, 15, 16 and 17, are effectively, well, 13 is a statement that you shouldn't construe this as advice and you should take your own advice. Fine, that has nothing to do with reliance on representations. And 15, 16 and 17 is a statement of the risks, of the nature of the risks, I think I should say. And again, that doesn't preclude ALAWWAL from relying on representations that might be made to it by Ribble. As far as the RFP disclaimer is concerned, one finds that at it's item 22, which is at the bottom of page 8 of Annex B. And it is relied on by Ribble as excluding any liability for the information and opinions contained in the RFP itself. I think it's important to stress that these disclaimers only relate to the content of that document. They don't relate and have any bearing on the oral representations that we are alleged to have been made. So the elements that, if one analyses and breaks down this disclaimer, number one, it says that there's a statement that Ribble does not represent or warrant the accuracy or completeness of the information in the RFP. The second element of it is a statement that Ribble does not accept liability for any loss arising from the use of that information or opinions. The third thing is a statement that Ribble makes no representations or warranties regarding future performance. And finally, there is a statement that the RFP is prepared for general circulation, as intended for general information purposes only, and is not tailored to the specific investment objectives, financial situation, or needs of any specific person, and that prospective investors are expected to make their own independent assessment and should not rely on this RFP. Now, in my submission, these notices are negated by the conduct of Ribble and the circumstances in which the RFP was provided to ALAWWAL by Ribble. And those circumstances, I think we rehearsed them quite a bit, are the exchange of emails on the 2nd of January 2019, which Your Honour will find at F110. I think if we could go to that. So I think the first email begins at the bottom of 110 and is from Mr. Ali Ibrahim. And it is him saying, "Dear Haroon, Demetrius, etc." They talk starting the process of becoming clients. But he says, "For now we're carrying out due diligence, and for now we kindly request the following: business licenses, etc., etc." Then the last bullet point: information in relation to the company's risk management policies, procedures, and controls. So it's a specific request in relation to the fund's risk mitigation measures and risk management policies. Mr. Ahmad engaged with that question. He didn't say, "Oh, have a look at the offering memorandum," or anything like that. He said, "Our risk management policies are included in our RFP. Have you got a copy of that?" And then subsequently it was sent. Now, we say that those circumstances necessarily was an invitation to rely on those documents and a representation that he was entitled to rely on them. And that's pleaded in the particulars of claim, paragraph 22 of the amended particulars of claim. And it's dealt with at paragraphs 19, 20, 128, 129, 130 and 140 of the skeleton. So it's quite an important point for us. There is, in the Taberna case, this is specifically dealt with. Now that's part of my learned friend's authorities. It's in their authorities bundle. I think it's their last authority right at the back of it, which is tab 12. Thank you. So that's E2, tab 12. And the relevant paragraphs of the judgment are, firstly, paragraph 11, which Your Honour will find at page 11, tab 12. And the context of that is that there is a disclaimer, which one of the lines of it was saying essentially that this is only for the purposes of investors who attended a particular roadshow. And the claimant in this case doesn't actually fall into that category. And the comment in the middle of paragraph 11, about 4 or 5 lines down, is, however, if a company actively invites potential investors to make use of information originally produced for a different purpose, it can hardly complain if they do so. next relevant paragraph is the whole of paragraph 12. In the present case, the judge found that Roskilde intended that potential investors should have access to and rely on the investor presentation for the purpose of deciding whether to invest in its subordinated securities generally, and encouraged Societe Generale to direct Taberner's attention to its website. Mr. Baer submitted that the investor presentation was intended only for use by those who were thinking of investing in the new issue of notes, but the judge's findings do not support such a limited view. In those circumstances, the judge was, in my view, entitled to hold that Roskilde had deliberately made the investor presentation available to Taberner with a view to it relying on it for investment purposes, and that as a result, any representation it contained were made by Roskilde to Taberner when considering whether to invest in its debt generally, including the subordinated notes. And the final thing is paragraph 26, which is on page 16 of this tab. And it's halfway down, 4 lines down, he says, Lord Justice Morbick says, the disclaimer may, of course, be overridden by dealings between the parties, but the judge's findings do not go far enough for that to assist Taberner in this case. So, Taberner is...
What does that mean? The disclaimer may be overridden?
It's overridden by the dealings of the parties. So if the parties, by their dealings, evince an intention to the contrary, then that overrides the disclaimer. So whereas the disclaimer says you shouldn't rely on this, it's for general information purposes only, Mr. Al Ibrahim asks a specific question about risk mitigation measures. Mr. Ahmad comes back and says, if you're asking about our risk mitigation measures, they're all set out in the RFP document. Do you have a copy? No, here's one. That is essentially overriding or negating, by their dealings, any disclaimer that appears in the document, because it is specifically inviting ALAWWAL to rely on the information in the RFP in relation to risk mitigation measures. And so, Taberner, in my submission, provides the authority for the proposition that, in this instance, the dealings between the parties has overridden the disclaimer that is relied on by Ribble and appears in the RFP and is set out at 22, item 22 of the Annex B to their skeleton argument. Now, during opening submissions and cross-examination, Counsel for Ribble has repeatedly sought to stress that the RFP and the PowerPoint presentations were just general information and that Mr. Zographos was just a salesman. The implication being that you shouldn't rely on them. You know, the salesman is just puff and this is just general information. But that again is negated by the 2nd of January exchange of emails. The fact that Mr. Zographos, well, the fact that Mr. Ahmad specifically says in answer to a specific question, the answers are in this document. Have a look at it. It is also relevant that you cannot run an argument that Mr. Zographos and Mr. Ahmad are just salesmen. You can't rely on them as anything being material if you don't actually bring them to court and get them to give evidence. So it's saying Mr. Zographos was just a salesman, but he's not here. We can't put to him.
Well, I think one of the other points you make is, what's the relevance of him just being a salesman anyway? I mean, salesmen can make misrepresentations.
Well, the next point is that precisely. The fact that
I think the way it's put is that because they were salesmen, one has to take what's being said with a pinch of salt. And I think it's being said that some of what's being said were just general puff, etc.
Yeah.
But at the moment, it seems to me that if a salesman makes what would otherwise be an actionable misrepresentation, I don't at the moment see why the fact that he's a salesman has any real business of it.
As I say in in my outline submissions, a salesman is no less a representative of
Well, he may be,
Ribble.
but I mean, assuming that he's being put forward as such, then
Yes.
yes.
Mr. Zographos was the account manager.
Yeah.
He was managing the relationship between them, so he had a responsible position, and he was effectively responsible for everything that ALAWWAL was being told. So in my submission in that context, he was no less authorised than anyone else to speak on behalf of Ribble, and his representations should be relied on as much as anyone else's. The second point about the mere puff, a subsidiary point, is, I mean, it has two answers to it. One, the first one, just because he's a salesman doesn't mean it's mere puff,
Yeah.
and you can't rely on it. But the third, allied to that, was if you want to make that case that he is mere puff and you can't rely on it, well, you need to bring that witness.
Well, I'm not sure about that. I mean, it seems to me that I'm not sure what bringing him here adds to that. I mean, I can see it may well affect the question as to whether or not I accept that he did make representations. That's your drawing inferences point, and will land on your evidence point. But why does he's just a salesman require him to give evidence? I mean, your clients accept he was a salesman.
Well, except he was a salesman, they do not accept that what he was saying was mere puff.
No, well, I agree with that, but I mean,
Yeah.
it seems to me that whether what he was saying was mere puff, well, I think it depends largely on what he was saying, doesn't
Yeah,
it?
I agree with that, of course. I agree with that. I mean, the first question
This
is what did he say?
This is a wonderful fund.
Yeah,
You know.
yeah. Yes. No, which he's not alleged to have said.
No, I know.
But yeah, if he had said that, then it would not be an actual
Yeah.
representation. It would be mere puff.
Yeah.
Yeah, absolutely. I think the point I'm making is if they are trying to run that, and they were saying that the representation was mere puff, I would have wanted to actually cross-examine him on what he was saying, what his intentions were behind that, whether it was just saying this is a wonderful fund, or whether he was trying to impart information that he considered relevant to the decision that ALAWWAL was going to take as to whether they should invest in the fund or not. That's the point I think I'm trying to make. The PowerPoint disclaimer, which is note 21 in the in Annex B, I mean, it's similar. It has the same elements to the RFP disclaimer.
Which number is this?
So this is 21. It's on page 7 of Annex B.
Yeah.
I mean, there's various statements like past performance is not an indicator of
Yeah.
a guarantee of future. Those are there. I'm focusing on 21, which is what I might call the meat of the disclaimer. And it's very similar in certain parts of it to what is said in the RFP. It's relied on for the same reasons. We say that similarly, the dealings between the parties have negated that disclaimer. I think I have to accept that our case on the PowerPoint presentation is weaker in terms of we don't have the 2nd of January emails as excluding or negating it. What we would rely on is, in particular, is that meeting on the 6th of February, where the team from Ribble went through the disclaimer, and it was really the start point for discussions, we say, and was specifically discussing and elaborating on and explaining the disclaimer. And it was being provided in response to specific questions that were asked by Mr. Malaika. My submission is that in that 6th of February context, the disclaimer was negated because effectively it was part of the due diligence process. Mr. Bitcon accepted it was part of the due diligence process. He accepted that Mr. Malaika was going to have questions, and they were putting up this presentation in response to those questions and elaborating on the content in response to those questions. So that is our case on that. Even if Your Honour takes the view that the PowerPoint disclaimer is not negated and that is effective as far as the content of the PowerPoint is concerned, that doesn't affect the RFP, and they broadly have the same content. In fact, the RFP is a document that we probably rely on more. And so even if you found that the PowerPoint disclaimer is not negated, the RFP one we say cannot be because of those 2nd of January emails, and it was quite sufficient for us to succeed on our case on the written representations that remains, or that disclaimer is negated. But as I said, neither of these disclaimers can affect the oral representations. They only refer to the content of those 2 documents. The oral representations upon which ALAWWAL seeks to rely were made at those meetings, and Ribble's case is that let's see, sorry, I've lost my reference. Yeah, so the oral representations were made at those meetings. The written representations contained in the document. The position of Ribble is that neither of those sets of representations, be they oral or be they written, can be relied on. And they say in particular that, that it wasn't reasonable for us to rely on. They weren't intended to be relied on, and they couldn't have foreseen that they were going to be relied on. Now, we say that that is simply not a tenable argument in the context of ALAWWAL seeking to make a decision as to whether to invest, asking specific questions in meetings and receiving oral answers to those questions, which the parties accept, particularly, or at least in respect of the 6th of February meeting, was part of the due diligence process. In circumstances where, with the exchange of emails on the 2nd of January, the RFP was expressly provided to answer questions and provide information, and where representations were specifically made in answers to questions. Now, might be helpful, we've looked at the oral representations, it might be helpful just to look at some of the written representations, and if Your Honour could go to paragraph 32 of the particulars of claim, which you will find Bundle A, tab 2, page 13. As I've said, there can be no dispute about what is actually written. It's there in plain black and white. But there are specific parts that we rely on, and we plead these at paragraph 32 in relation to the RFP. Paragraph 3.2 of the RFP, it says the management of risk specific to each underlying transaction, the management of risk specific to each underlying transaction using enhanced multi-layered credit risk mitigation techniques. And this next one too, at page 6 of the RFP, is one that is particularly relied on. It says the fund focuses on capital preservation and uses risk mitigating factors including over-collateralization and credit insurance in order to reduce volatility and maximize return within the strategy's conservative risk profile, making it an attractive alternative to other asset classes. I think I've drawn Your Honour's attention to this before. It is conservative risk profile is essentially a written representation that this is a low risk investment. And then we have page 8 of the RFP. The fund seeks to secure quality collateral and practical controls for downside protection. The fund's approach for complex financing is to simplify it by ring fencing and carving out specific assets, controlling cash flows and designing self-liquidating end-to-end solutions as opposed to the traditional trade finance business of balance sheet assessment and unsecured lending. Over the page you have those sort of tick box there of all
the various securities and credit enhancements typically used in the fund. And the word typically means usually. So it is saying it's a representation that all of these are usually, and maybe others. And then subparagraph 5 there, page 9 of the RFP, stating that investment committee considers risk and risk mitigating factors throughout the approval process, and that risk mitigation is fundamental to our investment process. Your Honour can read these to yourself. Essentially the same representations were made in the PowerPoint presentation, but they are clear. This is not selling a highly speculative, high-risk investment. It is saying in terms that it is a conservative risk investment. It is saying that the fundamental approach is to control and reduce risk, and it coincides with effectively what was being said orally. As I've said, I think I said in opening, the relevance of the written risk representations is twofold. One, they are representations in their own right, but two, they tend to confirm what was said orally, because a lot of the risk, a lot of the representations that are made orally merely reflect what is said in the document, and we say that that evidences the likelihood that those oral representations were made. The assumption, and moving on now to negligence and breach of fiduciary duties, the assumption of a responsibility by RIBL and the existence of a duty care, I deal with at paragraphs 50 to 57 of my skeleton, and I don't think I've got very much to add to that. I don't think much has moved on. The existence of a duty of care and the nature of that duty in this jurisdiction are governed by statute, the law of obligations, and in the skeleton it sets out the various provisions and actually quotes them. It is, however, relevant that Rule 4.2.2 of the DFSA General Module expressly provides that in conducting its authorised business, an authorised firm owes a duty of care. It says, in conducting its business activities, an authorised firm must act with due skill, care and diligence. So you have two statutory provisions, the law of obligations, but you also have effectively section 4.2.2 of the DFSA General Module, which cuts across that and actually expressly provides that there is a duty of care as far as an authorised firm is concerned when it is exercising its authorised business. Now, I deal with that breach of fiduciary duty at pages 58 to 60 and quote the relevant authorities there. Why the statutory duty?
I think I asked you this in opening, but 85, where you say, as explained in the skeleton, the existence of duty of care and the nature of governed by the law of obligations. Section 4.2 expressly provides in conducting its authorised business. You say an authorised firm owes duty of care. What it says is conducting its business activities, an authorised firm must act with due care, skill, care and diligence. Why isn't why does that say that it owes the duty of care? I mean, what?
Well, you mean that it must?
It's
it may not
careful.
actually owe a duty to act in such a way to the person.
It's got to be careful, but it doesn't have to necessarily owe a duty. I mean, it begs the question of duty of care to whom?
It is framed in the language of a duty of care. That is lifted from the classic common law understanding of what a duty of care is in terms of a professional firm. Reasonable care, skill and diligence. In my submission,
well, I mean, let's test this. Auditors have to act with due skill, care and diligence. It doesn't mean to say that they owe a duty of care to potential investors in a company whose accounts they audit.
No, I mean they will owe a duty of care, I guess, to the company.
Yeah, they will. But it's yes.
Yeah, so the question of to whom that duty is owed.
Quite.
And in terms of the auditors, it's a question of remoteness and foreseeability, reliance. And one has to draw the line somewhere, and all the authorities to that effect. So, no, I accept that. The question is here, I mean, my submission is that that duty of skill, care and diligence is owed to the person with whom they're dealing when they're carrying out their professional business, as it were. As with an auditor, they owe that. There is no purpose in being required to act with due skill, care and diligence if that isn't a duty that is owed to someone. And my submission is that must necessarily be owed to the person with whom they are dealing when they are carrying out their business activities as an authorised firm. Yeah, so it may be helpful just to look at it in the actual provision. So it's 5.1, I think, of our so E1 5.1, page 2.
Yeah.
It's 4.2.2. In conducting its business activities as an authorised firm must act with due skill, care and diligence. I accept that it doesn't say that a duty in those terms is owed to anyone in particular. It is clearly a duty that is incumbent, an obligation that is incumbent on an authorised firm. In my submission, it only makes sense and has any effect if it is a duty that is owed somewhere, and my submission is that it necessarily must be owed to a client or to someone with whom they are dealing. If that is not, if you're not with me on that, then my submission is it will inform the law of obligations, because it actually makes clear that in all its dealings, that is the nature of the duty that is owed, and so provided other requirements are met in the law of obligations.
Well,
then
I mean, another way of looking at this, if you look at 4.2 as a whole, you've got principle 1, integrity.
Yeah.
Well, they've got to be honest and deal fairly.
Yes.
2, they've got to be careful. 3, they've got to have proper management systems and controls.
Yeah.
And 4, they've got to have proper resources. 5, they've got to observe proper standards in financial markets. Now, in one sense, all of those are slightly motherhood and apple pie. But I mean, for example, it means that they can't, act in, some tiny firm can't act in relation to a matter where it's plainly inadequately resourced for dealing with a business that it's undertaken.
Yeah.
And given that these are regulatory requirements, I'm struggling at the moment to see how your submission that these show that there's a statutory duty of care, does it mean there's a statutory duty of honesty or a statutory duty to have management systems and controls? Anyway.
Well, if you're not with me that it imposes statutory duty.
And I mean, I'm just
Yeah.
flowing on from that.
Yes.
In the circumstances of this case, I completely understand how it is that you say that RASMALA made misrepresentations to your clients, and I completely understand how you say that as an authorised firm they've got to observe high standards, etc., etc. I understand all of that. But I mean, RASMALA weren't your investment advisor. You weren't going along to them and saying, can you please go away and find us a really good investment in which to... They were acting as salesmen for the fund which, as it were, bore their name.
Yeah.
So duty of care looks like an odd thing to to have in this situation?
Well, I think I mean, I deal in the skeleton argument with White and Jones, etc.
Yeah. Well, I understand that, but White and Jones is a situation where, absent the imposition by the courts of a duty of care, you get a loss without a duty, or a duty without a loss. You know, the executors can sue for you being careless, but they haven't suffered a loss because their estate has been augmented. It doesn't, at the moment, seem to me that the basis upon which one looks at White and Jones is the same. Here, you could have employed a third-party firm to look for a decent Sharia fund, but you didn't. Now, as I say, that doesn't affect the position as to whether or not you can sue RASMALA for misrepresentation, or indeed, in that context, as to whether or not the fact they're a regulated firm and so forth doesn't impose statutory duties on them. It's just the duty of care I'm struggling with.
Understood, Your Honour. I mean, what I'm saying in terms of White and Jones is that there was an assumption of responsibility.
Well, I know you are, and I understand that. I mean, the language by which one tries to decide whether or not the duty of care is involved has during your and my professional careers, gone through several things. Anyway.
Yeah. Well, we're saying we're referring to this particular obligation, duty, and we're saying it sort of effectively cuts across the law of obligations and creates a duty of care.
Yeah.
If Your Honour is not with me on that, I say it is relevant to the consideration of whether that arises. And of course, what I would say is, whilst we're in this tab, if we can go to 5 rather than 5.1, because we're there and it's handy, it'd be sensible just to look at just the conduct of business rules, and 3.2.1, which is on page 2 of the tab.
Yeah.
When communicating information to a person in relation to a financial product.
Yeah. Well, I mean, I understand that, and at the moment it seems to me that in relation to the conduct of business rules, etc., that's a rather good point.
That's the statutory duty, and whilst we're here, so we don't go back again, 3.2.2 is the provision that prevents the exclusion of liability on that basis.
Yeah.
And we rely on that. So that COB 3.2.2 is why we say that our statutory duty claim is the wrong word, maybe, impervious to disclaimers and those defences, because they simply can't rely on them in that context. And the claim for breach of statutory duty, which is set out in some detail in the skeleton argument, and I dealt with it in some detail in my opening submissions, it's brought primarily under Article 94 of the regulatory law. I don't know if it's helpful to go and look at that, or whether Your Honour is, it might be sensible to. It's back in, bundle E1, and we start at tab 1, and it's Article 94. I'm sorry, I'm looking at it in paper. I'm not sure. It must be about 8990 or something thereabouts in the electronic bundle, Article 94.
Page 96.
96. I'm grateful. It's 96, Your Honour.
Sorry, it's which tab is it?
So it's tab 1 of our bundle E.
Yeah.
E1, I think, E1. And page 96 of that tab.
Yeah.
So it provides where a person, A, intentionally, recklessly or negligently, and obviously we're saying here it is negligently, commits a breach of duty, requirement, prohibition, obligation or responsibility
imposed under the law or rules or other legislation administered by the DFSA, or commits fraud or other dishonest conduct, we're not relying on that, the person is liable to compensate any other person for any loss or damage caused to that other person as a result of such conduct, and otherwise is liable to restore such other person to the position that they were in prior to such conduct. Now, just pausing there briefly, this breach of duty, requirement, prohibition, obligation or responsibility, that covers, we've just looked at 3.2.1 of COB,
Yep.
the duty to be fair, clear and not misleading. And it also covers others, which I'll go to in a moment.
As you said, in a sense, this is your clearest and most straightforward way
Yes.
through.
Yes.
Because you say they're regulated, they're making statements in relation to the financial product. This imposes a statutory duty and there can't be any disclaimers. And
Yes.
that gets rid of...
It clears the clutter out of the way. And then 2 is also relevant. The court may, on the application of the DFSA or a person who has suffered loss or damage caused as a result of conduct described in Article 94A, make orders for the recovery of damages or compensation, recovery of property, etc., etc., except where such liability is excluded under the rules administered by the DFSA. Focusing on, to establish this claim, we've got to be dealing with duties or prohibitions arising under laws, rules, legislation administered by the DFSA. That includes the regulatory law, includes COB and the collective investment law. Now, it's relevant there, whilst we're in the regulatory law, to go back to 41B. Must be round about 31, 32 of that tab. And it is the general prohibition against misconduct. I don't know if Your Honour has got there.
No, but I will be. So which one?
41B of the regulatory law.
Page
36, my learned friend is telling me, that's which I'm grateful.
Yeah.
So a person must not, in or from the DIFC, engage in conduct in connection with a financial product or financial service that is misleading or deceptive or likely to mislead or deceive, fraudulent or dishonest. We're only in the business of 41B1A. And I think on opening I followed through the definitions of financial product and financial service, and they deal with a share or a unit. So that's one of those other statutory duties or prohibitions. The other is in the collective investment law, the other one on which we particularly rely. That's behind tab 4, and that is Article 56, which is sort of about just over 3/4 of the way through, probably about 35 or something like that.
50 what?
56, Your Honour.
Yeah.
I have it. You're there. So 56, focusing particularly on 56.2, because again it's more straightforward. A person shall not, in or from the DIFC, so it's sounding a bit like 41B of the regulatory law, make a misleading or deceptive statement in relation to a fund or in connection with an offer of units, whether in the DIFC or elsewhere. So that is another statutory obligation under a law administered by the DIFC that we say a misleading representation breaches. I would also submit that where a false or misleading statement has been made, those provisions we have looked at impose a continuing duty to correct that statement. So much as if an ordinary misstatement had been misrepresentation, would mean that there's a duty to correct. So in the case of a misleading statement made in breach of a statutory duty, there is a continuing duty to correct that.
And that is, we plead a continuing duty to correct in our
I
particular.
mean, does that have any factual relevance in this case?
Not sure that it does particularly. I
I
haven't
mean,
thought through.
Well, I mean, it seems to me that if you're right about the misrepresentations or the misleading statements, they're misleading at the time they were made. I can't at the moment see that there's anything which wasn't misleading at the time that it was made which would become needs to be corrected. That seems to me to be, how shall I put it, adding unnecessarily to my judgment.
The only context in which I can see that might happen is if someone was unaware, or I think on November the 14th, the loss of the assets under management had not yet taken place, but it had taken place by the February 6th meeting. But I agree with you, Your Honour. It's probably not something with which Your Honour needs to concern yourself now.
I'm not anxious to make my judgment
longer or more complicated. Now, 3.2.2 is very similar in terms to Rule 2.12R of the UK Conduct of Business Rules.
Sorry, which one is it?
So 3.2.2, that's the one that prevents a disclaimer.
Yeah. And then you take me to Hockhauser.
And I take you to that, yes. Have you looked at those?
I have.
Then I won't take you there. But I mean, what he has basically said is that that particular provision in the UK, at least, goes further than UCTA. UCTA is in the same terms. The act out here is in similar terms to UCTA, but it goes beyond that, and it actually excludes basis clauses, and is, in my submission, clearly sufficient to exclude the disclaimers and the notices that we're dealing with here. So I think what Palmer and Barclays Bank does is just confirm the effectiveness of that particular provision. There is a statutory duty under 3.4.2 of COB to assess suitability. And we've looked, and I'm not going to labour this point, I think during cross-examination we went through the terms of business 3A, we went to the account opening form and the ticking of the low risk and medium risk boxes. And then we had the exchange of emails between Mrs. Vyas and, which is at F172, where Mr. Zographos says that ALAWWAL's risk tolerance was high. Completely untenable, no basis, no innocent basis for saying that. But that is another area in which there has been a breach of compliance obligations in this regard, and one has to raise the question why. Now, we couldn't ask Mr. Zographos why he said that their risk tolerance was high, and that's unfortunate. But it's another area where there has been a lack of transparency, there has been a failure to comply with the obligations, the regulatory obligations of the firm, etc. It really only left to deal with loss. I think I deal with the loss at paragraphs 98 and 99 of my outline submissions. The first table I set out there is...
Sorry. Let me just get your submissions up first.
Of course.
Now, the series of questions that I raised on Friday afternoon...
Yes.
You've got a table, I think, somewhere, about the redemptions.
In my outline submissions?
The paragraph 98.
Yes.
Are they... do they total the... No, they don't. They don't total the... Do they? They don't total the total number of shares, do they?
No, I think this is... oh, sorry, the shares there. My understanding is that this table is the correct total of shares that have been redeemed at 59,438.19.
Yeah.
And is correct in terms of the amount of money that has been received for those shares.
Yeah, hang on, let me just... Right, so the first redemption is of 32,000 odd shares at $83 a share for 2.7 million in January 2022, and the last one is
25th of November 24.
yeah, it's a redemption of 522 shares at $59 a share in 21st of Jan. Now, oh sorry, it's not the last one. That's
And it's over the page. I apologise. It's
yeah.
over the
But
page.
the point I've got for you is that I think that still leaves ALAWWAL holding some shares.
Yes, I
So
think
one of the questions I got to you is, well, what do I do, if anything, about the value of those
Yes.
shares?
the parties have discussed this. I mean, initially we thought we held shares. I think what we have is rights under a trust in which
Right.
those shares are held.
Right. Well, that was again one of the questions as
Yeah.
to what they were actually.
Yes,
But,
good. Well, when I pleaded the particulars of claim, my understanding was we held
Okay.
shares. It became clear during discussions that we don't, that we have, and that flows from, I think, the subscription agreement where the subscriber was.
Well, look,
was
I mean, I haven't looked at these provisions, and
Yeah.
I'm not particularly keen that I have to do so.
No, I don't think Your Honour has to.
Well, the relevant question I think is this. One is, in my judgment, at some point, I'm going to have to say, X shares were redeemed for Y dollars, and
Yes.
paragraph 98 gives me that.
Yes.
I would like to know at least by what mechanism that's done, which was one of the questions I raised on Friday afternoon. In
Yes.
other words, if it's done by a trust, I at least want to know what the references are. But the more relevant question, or possibly the more relevant question, is whether there is any value left,
Yes.
and if so, what's going to be done about them.
Well,
in
we have
relation-
agreed to assign.
Right, so you're going to give the
Yeah.
shares back.
So we decided the easiest way, we accept that if Your Honour decides we're entitled to compensation,
Yeah.
then we are compensated once and for all, and we can't then hang on to
Right,
shares
so,
or
so,
interest.
so you're going to give the shares back.
Indeed.
Right. Okay. Well, that's.
So
really-
that's the simplest and cleanest way of
Okay.
dealing with it.
Well, I think what I'd like in relation to that is if that's agreed between you, some form of brief written statement adhered
Right.
to by both parties identifying that.
Okay, I understood.
So that's one question I had for you. Yeah, well, I think that deals with most of the sort of more detailed questions. Sorry, Mr.
So just on that, Your Honour, just in case it assists, I understand there's a signed agreement between the parties, so perhaps if we
There is already a signed agreement.
I think the situation, to be fair, I'd say that there were a signed one.
sorry.
It is actually with our clients at the moment.
Sorry, my learned friend's right, but those instructions you just
Right.
corrected.
Okay. Well, in that case, if this is all under consideration, let's not waste any more time on it in relation to it. I'm grateful. So the practical position is going to be this: there's going to be an agreed amount which you've got credit for. There's going to be an agreed mechanism, and someone's going to tell me where I look if I'm interested to see how this is all dealt with in
Yes.
terms of the agreements.
Yes,
Fine.
exactly. So I set out in some.
I'll ask Mr. Berry in due course, but I assume these numbers of paragraph 98 are agreed, or if they're not, they're going to be identified.
Yeah, to be honest, I think Mr. Biru is in a better position
Right.
to
Okay.
provide you with the precise details.
Okay, well,
This
it
is
sounds to me as if the parties very helpfully dealt with the substance, what I was asking about on.
yes,
on
the subject only to our clients finally signing off.
Okay. Well, I better get on with
And I'm not anticipating a problem with that, but I can't give any warranties
it.
on that.
Right, okay.
So then 99, I think, tots up the losses, that table there. And then there is the final bit, literally the final points I want to make on this, on my submissions before I sit down. I don't know how I'm doing on that.
Well, you're getting close to the end, but and you were also getting close to a break. But paragraph 100, as I
Yeah.
understand it, you put in a sentence. What actually strikes me as being quite an interesting little issue, where, as I understand what Mr. Beru said, I think to be fair in opening, and about which he cross-examined, and which he certainly put in. No, he hasn't put it, but anyway, it's in his opening. He effectively says, look, you were looking at two funds. Why should you get the fund which gets you 6.5% as opposed to the other fund at which you were looking? Now, I can't confess that I've spent an awful lot of time looking at this, but I think he's going to say that he's got the evidence to show that the alternative investment wouldn't have been the one for which you contend. What do you say about that?
Well, I can't really go beyond what Mr. Al Ibrahim said in
Right.
his witness
I
statement,
haven't-
because
right, sorry, go on.
whether what we would have done is a issue of fact.
Well, I think there are two things. I haven't. I'm sorry. Amongst various other things I could have done, I could have gone back and looked at the question Mr. Barrow asked him. But I think Mr. Barrow is going to tell me that the effect of Mr. Al-Abraham's evidence should be that I should say if they didn't invest in his fund, they'd have invested in another fund,
Yeah.
and that doesn't give them the same rate of return.
Yeah. What Mr. Al-Ibrahim said was that they took the money out of the Daria fund specifically to put in here. He says it went into a big pot. My learned friend, Mr. Biru, is going to say, well, actually, it wasn't precisely that money. I would say.
Well, I think he's going to say that, but I think he's also going to say that if it hadn't gone into your fund, it would have gone into another pot, and therefore you shouldn't get any more than that other pot. I think that's what he's going to say.
Yes. Okay. We say that our evidence is that we've gone into the Daria fund. There was clearly an opportunity cost, and one or the other is that
Okay, well,
opportunity
I
cost.
think what I'll probably do is I'll hear what Mr. Barrow actually has to say, who presumably has looked at the evidence and also presumably was cross-examining by reference to what he was trying to achieve in relation to it, and probably knows whether he's got the evidence or not.
And
then
once I hear
you
what
will
he says,
reply.
I maybe come back and reply on that.
Yeah.
Yeah. Your Honour, unless I can assist you further, I think those are
No,
my
I don't think so. That seems to me to be a sensible time to have a break as well, so we'll come back at 10 to 4, and you have by, sorry, not 10 to 4, 10 to 3, and
I've done rather better than was
yeah,
anticipated.
and that should leave you plenty of time if you need it tomorrow. Stewart.
Good afternoon, Your Honour. My learned friend has been commendably brisk. He's gone a lot quicker than I anticipated. Nonetheless, Your Honour, what I'm going to do is move through my closing submissions. I'm of course unlikely to conclude them today.
Yeah.
But as I said earlier in the hearing, what I will do overnight is send you my outline skeleton that will have all the references. And I hope, Your Honour, that will save me from having to read into the transcript all the references to the cross-examination. However, of course, if Your Honour wants to be taken to a specific one, then I can do so. So Your Honour has heard all of the evidence he's going to hear now, and we say that the oral evidence that has been heard over the past few days confirms and supports Ribble's defences to the claims, and what we would do is invite Your Honour to dismiss all of ALAWWAL's claims, specifically the misrepresentation claim and everything that flows from it. And that is quite key, Your Honour, we say, because a lot of their other claims, if not all of them, are predicated on Your Honour having found there were misrepresentations made, and that they relied on those misrepresentations. Now, I intend to deal with 9 topics in this order as part of my closing submissions. The first is I'm going to touch upon the pleadings, because I think that's important in this case. The second, I wish to address Your Honour on what I say should be the court's approach to the evidence, both the documentary evidence as well as the oral evidence. Your Honour, then what I will deal with following this order, just as a matter of logic, is the oral representations, the written representations, reliance, the advisory duty, the regulatory duties, fiduciary duties, and then finally I'll deal with quantum and loss. So those are the 9 topics I hope to hit in my closing submissions. Your Honour already has detailed skeletons from both parties and has heard oral substantive openings. So what I would try to do is focus a lot of my submissions on actually the evidence that has come out, which we say is of significance and importance to the case as a whole. So where I want to begin with is that in my submission it's vitally important for the court to have well in its mind when reviewing the evidence as a whole what it is each party has to prove. And there's 2 points I wish to make on that. The first is that ALAWWAL very much bears the burden of proving its claim for misrepresentation, breach of statutory duties, and all the other heads of claims that it advances. It's an obvious point, But just to put it into context, what that means in my submission is that ALAWWAL must prove that each of the 7 oral representations, the oral master representations, as well as the 5 written master representations, were made, and if they were made, that they were actionable. The second thing it must
Well, sorry,
do is,
let me just understand what you mean by that. I mean, of course, they've got to plead and prove the representations upon which they rely. And if they don't make out a particular representation, either because I find it wasn't made or because I find that it didn't fulfil the requirements of an actionable representation, or because there was a valid disclaimer in relation to it, then their claim in relation to that misrepresentation fails. I understand that. But you're not saying, are you, that they need to plead, or that they need to prove all of their misrepresentations in order to succeed?
well, Your Honour has to consider them individually.
Yeah.
Because this is one of the.
Yeah, I mean, I have to look at them individually.
Yes.
I agree with that.
And Your Honour has to consider whether they were made, whether they are, if the statements were made, whether they are actionable, and if they are actionable, were they relied upon, and if they were relied upon, and they were entitled to reasonably rely on them, whether the falsity of that representation has caused loss.
Okay.
And this is what my learned friend.
Well, let's just break that down. So
Yes.
I'm with you up until the point at which you say you've got to establish reliance and reasonable reliance. So
Yes.
take that far. Let's suppose that they fail on all representations save one,
Yes.
and I find that that was an actionable misrepresentation. They were entitled to rely on it. They did rely on it, and so forth. Now, at that point, are you saying that there's some other issue in relation to loss here?
Well, yes, Your Honour, because what insofar as in that example where there's one, let's say there's a representation that they make which is the written USD representation. They say it's one of the representations that were made that they relied upon. If Your Honour were to find that is a representation that was made and they relied upon it,
It hasn't figured at the forefront of the
it
case.
hasn't, but it's the extreme example, Your Honour, but it's an example that could exist on the
Now, I understand. So I mean, I suspect that might fail at the reliance and reasonable reliance stage, but I understand the point you're making.
Yes.
If it was made, then where's the link between any loss suffered and a breach in relation to the written USD?
That's right, Your Honour.
Well, let's take a dare I say it, a more realistic one.
Yes.
In relation to the question of defaults. Now, I've got your point that I've got to look at what the misrepresentations were and go through all that. But say in broad terms that I get to the point where established reliance and reasonable reliance and the representation which is found effectively relates to the fact that there were no or minimal defaults. Is there some issue in relation to loss there as well or not?
On that particular example, Your Honour, I would say probably not, because it's what is a major representation that they say was a. I think they do put it, and it is pleaded that is a sole basis on which they did invest in the fund.
Yeah.
The issue here is the lack of clarity. There is a catch-all, which is if you look at them individually or you look at them in isolation,
Yeah.
that there's a misrepresentation and that induced us into investing. But actually what there isn't is a breakdown of which ones of them actually had a material impact. Are they saying they needed all of the representations to be made and that was the basis on which they were induced to invest? Or are they saying that each one individually was enough and that induced them to make
Well, I mean,
the
two points as to that. I'm not criticising anyone, but I don't think there was much division or analysis. I mean, I'm expressly not being critical, but you didn't, for example, cross-examine on the basis of the US dollar one and say if that was the only thing wrong, it wouldn't have made any difference to you, or words to that effect.
I didn't cross-examine on it because I don't dispute that representation was made.
No, but let's assume it was made. The question of reliance is then potentially important in
Yes.
relation to that.
Yes, did they rely on it for the purposes of making the investment?
Yeah. I can't know, but I think the Saudi real is pegged to the US dollar, isn't it? But
I'm not sure. I think that is the case. But
I mean, if you take another reputable currency which isn't pegged to the US dollar,
yes,
would it have made any difference to you?
correct.
Yeah.
So we say that is important, but one of the other important points, Your Honour, on this is the falsity element.
Yeah.
And my learned friend didn't really address you on falsity.
No, well,
at
I mean,
all.
that's it's a point well made. I mean, it's obvious that what his case is in relation to falsity in relation to some of the misreps, but what is his case in relation to falsity about US dollars, for example, is what
Yes.
you're presumably going to make.
Yes, well, I would say it does go further than that, Your Honour. I would say in respect of all of the representations, addressing you on falsity is critical because a lot of the pleaded case is based on inference, but they don't quite accord with what the case on the representation is as I understand it to be. So, for example, if we go to probably the most important one, the multi-layered risk mitigation
Yeah.
measures. In the pleaded case, all it is said in respect of falsity is that it is to be inferred from the fact that Farlin and Metrade were defaults, that risk mitigation measures were not applied, or multi-layered risk mitigations were not applied. But is that actually correct? Why is that false? Where does the inference come from? And to make the point good, Your Honour, we've looked at these transactions quite a lot over the past week.
Well, we looked at some of them.
Well, specifically Metrade and Farlin is what I'm talking about, because that's what the pleading is based on. And in both of those cases, it's obvious there was more than one risk mitigation technique that was applied. So if we look at what it means for a multi-layered, it's more than one. That's what I would say the interpretation of it is. It may be that it's 2, it may be 3, it may be 9, it may be 5. We saw the case studies that showed the difference between 9 and 5. But there isn't a case that's advanced, or at least one that I've understood, which is this is why what you said in respect of multi-layered risk mitigation techniques applied. This is why it's false. And what I would have expected is to say, well, here is the evidence that there are transactions where you only applied one or you didn't apply any. But we don't really get that far. All we have is an inference that just because those investments led to losses, that there must not have been risk mitigation techniques applied to them. And that is, we say, demonstrably false from the documents there are before.
Well, you're saying,
Go on.
well, what you're saying is that it doesn't show that the representation was demonstrably
Yes,
false.
yes, exactly.
Yeah.
Now, the second point I wanted to make, Your Honour, just on the kind of the starting point is that, and again, it's an obvious one, but ALAWWAL must prove its case, and Your Honour is only entitled to determine and consider the issues in this case, in my submission, by reference to what is pleaded.
Yeah.
And in my submission, I will deal with the importance of pleadings first, because it does seem to me that from the submissions I've heard from my learned friend as well as the cross-examination, we have deviated quite far from what the pleaded case is.
Well, I mean, look, you can take me to the importance of pleadings if you want, but I don't at the moment think you need authority for the proposition that the case needs to be determined in accordance with the pleadings. I think what I do need to know is what aspects of the case closed by Mr. Adair you say are outside the existing pleadings. That's what I do need to know.
Yes, Your Honour. Well, I'm grateful for that indication, and I have, just for completeness, cited the Credit Suisse and Arabian aircraft case in support of that proposition. And it's not limited to the way in which my learned friend closed the case.
Well,
obviously,
opened that.
Yes.
I mean,
so
ran his case.
Yes. Well, there are 5 areas where I understand ALAWWAL to be saying something that's different from what is the pleaded case. So the first area is this oral 0% risk representation. Now, in ALAWWAL's oral opening submissions, it suggested that the oral 0% risk representation should be interpreted as meaning the fund was a very low-risk investment in those terms. And Your Honour, I can give you the transcript refer if you'd like, but it will be in the note that I circulate overnight. But that is not its pleaded case.
Yeah.
And its pleaded case is at 29.4 of the amended particulars of claim, which is A2 at page 12. Your Honour, I don't propose to turn it up unless you'd like to see it.
But the alleged representation there is not that the fund was a very low risk investment, it's that there was a 0% chance of making a loss when investing in the fund. And we say that is fundamentally different to the fund being a very low risk. Very low risk obviously is not the same as zero risk. So in my submission, that's one of the reasons, and the first area in which we say ALAWWAL is seeking to move away from the pleaded case. And we say the reason for that is because it's a recognition of what I would call the inherent implausibility of such representation being made by Mr. Zographos as a professional. And indeed, it was floated as an alternative interpretation of that representation upon my learned friend engaging in discussion with Your Honour, where you said, well, nothing in life is really 0% risk-free.
No. But I mean, let's just explore that one. I mean, I take your point, and but let's just explore that one.
Yes.
This is an alleged oral representation, isn't it? So suppose Zographos says, look, there's a 0 chance of you losing money in relation to this. Now, what you've just said is that shows that he's unlikely to have said it, and I understand that.
Yes.
The second way that you could put it is that no one would have understood him to be literally asserting that there was a 0% chance, and potentially that therefore means that you weren't entitled to rely on it. That's the
Yes.
second way you could put it. The third way you could put it is, the third way it could be put is that one wouldn't understand that literally, but one would understand it to mean that there was a very low risk, which is, I think, the way that Mr. Adair wants to run it. And you're saying that isn't open to him on the pleadings. If he was going to say that, he needed to say, although parties didn't understand that to mean literally there was no risk, it was understood to mean it was very low risk or fitted the objectives or whatever it happens to be.
Yes, that's right, Your Honour. But I would say in between your first and second example, if Your Honour is with me, which is what that effectively was, if it was made, which we don't accept, is a generic sales talk, something that's not objectively verifiable. It's not actionable in the first place.
This is the world's best fund.
This is the world's best fund, exactly. But Your Honour has got the point, which is I say it's not open to ALAWWAL and Mr. Adair to deviate from it because they haven't pleaded their understanding or interpretation of that to have been very low risk. The second area, Your Honour, is to do with what is called the oral suitability representation.
Yeah.
And it was suggested in the opening that should be interpreted as containing a statement of fact that investment professionals at Ribble had carried out a suitability assessment and concluded that the fund was low risk. But again, that's evidently not the pleaded case. The pleaded representation, which is at 29.5 of the amended particulars of claim, which is A2, page 12, is that the fund was a suitable investment for ALAWWAL, having regard to its alleged investment objectives. So there's no reference in the pleading anywhere to an assessment of suitability having been carried out by some investment professionals prior to this meeting taking place. And that was the basis on which the representation was alleged to have been made by Mr. Zographos. To make the obvious point, Your Honour, it's not really even clear who these investment professionals are said to be, or could be, who would have determined the suitability of the fund. And of course, if an advanced pleaded case on that basis had been set out, we would have likely adduced evidence, we would say obviously, as to whether such an assessment had been carried out and what the process of that assessment would have been that could have led Mr. Zographos to have made that representation.
Okay, so let's just examine that. The reason I challenge that is this fund is suitable for you. Looks like, I believe, this fund is suitable for you having regard to your objective, to your investment objectives. Sounds like, one, I understand what your investment objectives are. Now, there's a dispute about that. You said it wasn't made plain, he says it was. But what is said is that it was made plain that they wanted a low-risk fund. That's what they say. So the representation is, I believe this fund is suitable for you, i.e. I believe implicitly this is a low-risk fund.
Yes.
That's a statement of opinion, save insofar as it is asserting I have a genuine belief.
Yes.
Now, as to that, there unquestionably was a challenge to Mr. Zografov's belief as to the risk appetite, because the case was expressly put to those who were available that the alteration of the risk profile by Mrs. Sorry, I've forgotten her name, but the compliance lady.
Yes.
Yeah, had no proper basis to it. Now, is that something which is open to him or not? In other words, being able to say, well, that has a representation of belief, and Mr. Zografos couldn't have believed. Sorry, there's another aspect of that. Normally, a statement of belief things with it. One is a statement, obviously, of honest belief, and the other is a reasonable grounds for it. And it was unquestionably put that there wasn't any reasonable grounds for the high risk.
Well, so just to break that down, Your Honour, on the way that you have set it out, I would say no, because the context is key here. And particularly in respect of, and I will come to deal with the email to Ms. Vias, I think that there's a fundamental lack of completeness in terms of the documents you've been taking.
I'm dealing
But
with
yes,
the
but in any
factual
event, well, that suitability, Your Honour, happens after. We're talking right now about representation that is said to have been made at the very first meeting on the 14th of November. That's where the suitability representation is first said to have been made by Mr. Zografos. And at that point, the context is key. It's an introductory meeting. He's never spoken to ALAWWAL or anyone from ALAWWAL before, as far as the evidence shows. He's turning up. Or the case on the other side is he is told that these are our investment objectives. We don't accept that. And then it's said that he said, well, yeah, this meets your objectives. Now, Your Honour is right, which is that is, in my submission, a statement of opinion on that particular example. And the question is whether, what could he have, if he did make it, what his belief could have been in the opinion that he was expressing, given he didn't really know anything about ALAWWAL. And this is where Your Honour's question about what does risk mean is quite important, because, well, let me try to address it now, Your Honour. In terms of risk, you have asked at numerous stages in the proceedings, what is low, what is medium, what is high risk. Now, had we known that may have been an issue as it was, one could have adduced expert evidence from professionals to deal with that. But my point on it is,
although I'm not sure that's necessarily admissible, because I think what's low and what's medium and what's high, maybe there's expert evidence, take that back, but I think it's to be adduced from the circumstances in which it is being put forward.
Yes.
And therefore the question is, what is low risk for a 60-year-old walking in the Alps?
Yes.
May be different from a 25-year-old guide who's ascended all the 4,000-metre peaks.
Yes, and Your Honour is rightly and as always one step ahead of me, and that's my point, which is what is the meaning of risk, and one of the reasons why you don't necessarily find it defined anywhere, particularly in regulations or rules, is because it's in the eye of the beholder. Risk means different things to different people. It's a subjective assessment. What may be considered low risk to me may be considered high risk to you. And we say certainly, if you look at the evidence that has come out, Mr. Ali Ibrahim's evidence, which is, well, it's money market rates, it's LIBOR 3 months, which at around that time, at least from the table that's provided, averages out about 2.5%, 2.6%. You're looking at an investment here by Ribble that was 5% above that. So a 7.5%, potentially a 7.5% return. And then we also heard evidence from Mr. Swats, and I think it was on questioning by Your Honour, that there are products that will give you a 10%, possibly more return. And just because this is not aiming to give you a 10% return does not mean it's not a high-risk investment if it's giving you 5%.
At some point,
But
I want to have a look at that LIBOR plus 5% figure, because although it was Mr. Swats was undoubtedly pointing to it at the time he was giving evidence, I haven't actually been able to find it again when I was looking for it. So
it's in the PowerPoint presentation.
It's the PowerPoint.
Yes, if you'd like, I can take it to you now. If that would assist.
Not necessarily. I'll look for it.
Yes,
myself.
it's in the PowerPoint presentation towards the back where it says the targeted return, expected return of the fund is. I believe, Your Honour, and I will dig out the reference, it's also in the fact sheets that are provided to the investors.
I think I was actually looking at the fact sheets and couldn't find it, but that may be my fault. Anyway.
I'll double check that and come back to you. So that's the second area, Your Honour. The third area in which we say there is actually a departure from what the pleaded case is, and this is quite an important one, which Your Honour touched upon, is the reliance on 4.22 of the Gen Handbook of the DFSA rulebook. Now, what I'd understood my learned friend to be saying is that ALAWWAL is relying on Gen 4.42 of the DFSA rulebook as imposing a duty of care on Ribble, and therefore it's unnecessary to consider whether there has been an assumption of responsibility, because that cuts across the law of obligations as he says it. But quite importantly, that is not what the pleaded case is. The only time Gen 4.2.2 is referred to in...
Sorry, I'm only smiling because you may have seen from what I've said that I wasn't immediately attracted by the way it is. But anyway,
Yes. Yes, well, Your Honour, I'm not going to labour the point too much, but just save to say this. It follows off the observation that Your Honour made, which is all that is done is that provision is quoted. It's not stated how the duty is said to apply, to whom it applies and why it applies, nor is it said to have been breached. So that's a very different pleaded case to what is now saying, well, it cuts across this and that's what's applied. But more to the point, and perhaps we can just very quickly look at it, and then I don't have to come back to it as well later, Your Honour. We would say what that reflects, what those principles reflect, is not that here's an imposition of a duty that you owe to your clients. This is the standard by which we expect authorised firms.
Well, I mean, just to drum our code here, I mean, it seems to me to be very similar, actually, to the sort of general principles that you get in, for example, solicitors, or for that matter barristers' regulation.
Yes.
You get
Code of conduct.
barristers shall act with integrity. Well, yes, right.
Yes.
Barristers shall act with due care and skill.
Yes.
Yeah, right.
Yes.
It doesn't identify whether, I mean, we know, or we normally know, that barristers owe duty of care to their client, but it
Yes.
doesn't mean that they owe duty of care to anyone who happens to come across them. I mean, that's at the moment how I see those principles.
Well, and I would say that Your Honour is right in his observation on that, and that is how it is applied. We would say a breach of Gen 4.2.2 by an authorised firm is one that gives rise effectively to disciplinary action by the DFSA against that firm.
Well, I mean, I haven't looked at it. It may even be that it's one of those things, it's one of those general principles which sort of stands above everything, if you see what I mean.
Yes.
Anyway.
It certainly appears that way, Your Honour, and the comparison to, for example, the solicitors' regulations or the barristers' regulations is apt, because they do refer to the overriding principles by which professionals have to conduct themselves. And Your Honour may find some support from this. If we go to E1 5.1 page 2, my learned friend did take you to this, but the guidance that's above the principles for authorised firms, we can see that what it says above it at page 2 is, in the small print, the principles for authorised firms have the status of rules and are general statements of fundamental regulatory requirements, which alongside the other rules and also in new and unforeseen situations which may or may not be covered elsewhere by Stewart, and it goes on. Then number 2, breaching a principle for authorised firms makes an authorised firm liable to disciplinary action and may indicate that it is no longer fit and proper to carry out the financial services or hold a licence, and the DFSA may consider withdrawing authorisation or the licence on that basis. So that may suggest actually the point which we've been looking at, which is this is only really applicable for the purposes of looking at whether they have complied with their regulatory requirements, and if they haven't, i.e. if they've acted in breach of Principle 2, 4.2.2, then what that gives rise to is disciplinary action, as opposed to it saying it's imposing a duty of care that you owe to your client, and the duty exists under this provision, and therefore one has a right to pursue a claim under 4.2.2. So, Your Honour, linked to that, which is the fourth area where we say there's been a departure, is the reliance on Article 41B, which you also looked at with my learned friend. And it was suggested in the opening that it was relied upon for the purposes of the regulatory claim. But again, that's not the pleaded case. Paragraph 45, subparagraph 10 of the particulars of claim, and the reference is A, tab 2, page 28. That is the only place where 41B is referred to, and it suffers from the exact same treatment that 4.2.2 does, which is it's just quoted, it's there. But there's been no pleading, there's no positive case pleaded that we have acted in breach of Article 41B. But in any event, I say that is significant, Your Honour, because Article 41B requires, in my submission, in any event, and I can possibly deal with the point shortly, so I don't have to come back to it, is as I say, that does require some form of deliberate wrongdoing. And perhaps if we can look at it, Your Honour.
Yeah.
It's at E2, tab 4, page 36.
Sorry, hang on. The wrong reference.
Sorry, John, I've given you a... Yeah. So,
Yeah.
E2, tab 4, page 36.
Yeah, this is the point which I think I raised with Mr. Adair in opening: misleading,
Yes.
deceptive, likely to mislead or deceive,
Yes.
fraudulent or dishonest. And the question as to what is meant in that context by likely to mislead or deceive.
Yes. Well, and also the provision, I say, does assist with the interpretation of that provision, which is it's a general prohibition against misconduct. Now, my learned friend relies on the word misleading in A, and he says, well, that's all we're concerned with. And the submission in the oral opening and implicitly in the closing submissions is that would capture a negligent misrepresentation.
I think he also relies on misleading or likely to mislead.
Yes, yes, that's correct, Your Honour. But those two elements of it, not the dishonesty elements. But in my submission, looking at this, I would say that construction is wrong, and I would say that all of what is included in subsection 1, so A, B, and C, is imposing a general prohibition against misconduct, i.e. deliberate acts that are intended to deceive in one way or another. And we would say that negligence is not ordinarily, in my submission, described as or considered as misconduct. Negligence is essentially a failure to exercise the care that a reasonable person in the same position would exercise in similar circumstances. It's about a lack of care, and therefore the acts leading to it are often unintentional. Misconduct would typically, in my submission, require an intentional or deliberate form of wrongdoing.
Or at the very least, objectively reckless.
Reckless, correct, Your Honour. And we say that interpretation, the one that I've just posited, is supported because the words misleading and mislead have to be read together with deceptive and deceive, which appear in the same clause at A. My submission, they're being used as synonyms. So misleading or deceptive or likely to mislead or deceive, they're intended to have the same consequence, which is there's some form of deliberate or reckless misleading or likely to mislead someone. And therefore we say the use of the words misleading and mislead is clearly intended to mean something more than negligence. And we say that that's further confirmed by the fact that the subsequent B and C use words such as fraudulent or dishonest. So they all form part of what we would say the same standard here, which is effectively you're looking for some form of deliberate wrongdoing, or at least some form of recklessness as to the wrongdoing. And if Your Honour is with me on that, what you don't have in the case and the particulars of claim is any allegation of deliberate wrongdoing or recklessness.
Yeah.
And therefore we say that insofar as ALAWWAL wished to pursue a claim under 41B, it can't be permitted to do so at this late stage. Your Honour, the fifth area, which is the last area that we say represents a departure, is the 2017 accounts. Now, much of the focus of ALAWWAL's cross-examination, skillful cross-examination by my learned friend, undoubtedly, but a lot of it was focused on the fund's 2017 accounts, how they were prepared, whether they were prepared correctly, what ought to have been disclosed, what could have been disclosed, what it even went so far as to suggest, well, what's the basis on which it was prepared by one auditor but not another? However, it is important to understand how the 2017 account fits into the party's case, which is in a very specific and very limited way, which we say confines the parameters by which Your Honour is really looking at the issue and forced to make a determination. Now, ALAWWAL's pleaded case is not, for example, that the 2017 accounts made a misrepresentation, or that they relied on it and they were misled by the contents into making the investment. Their pleaded claim is much more limited than that, and it actually doesn't rely on any allegations of misleading accounts or wrongful statements or omissions or anything like that. What they say, and Your Honour, perhaps given the importance...
I summarised it to Mr Adair, as I understand it, like this. They say they made inquiries about defaults. You say, well, you had the 2017 accounts, and that refers to defaults.
Yes.
I mean, I paraphrase. They say, well, we didn't read the notes. You say, why didn't you read the notes? They say they didn't read the notes because anything important would have been in the balance sheet. I mean, that's, as I understand it, how you get to the 2017 account.
Yes.
Yes.
Well, the specific allegation is we didn't read it. That's what came out in the evidence. But the allegation that's pleaded is you did not draw to our specific attention note 16 and note 3.1b.
Okay.
Now, the reason that's important, Your Honour, what I say is implicit in that pleading, but also it does come out of Mr Alabream's evidence, which I'll look at later, or I will come back to later.
Sorry, whose evidence?
Mr Ibrahim's evidence. Sorry, I may have mispronounced it. What is implicit in that pleaded case and what comes out of his evidence is he is saying, if I had read those notes, and I don't accept that he didn't read them, and actually his evidence is that he did look at some of them, but what he tried to say, or what he did say is, had I read this, I would not have invested. ALAWWAL would not have invested. So implicit within that is that the information that is contained in the 2017 accounts was material enough that it would have influenced their decision. That's what his evidence is. He says, if I'd seen these defaults there, I would not have invested. And that was actually in response to my cross-examination, as well as Your Honour seeking to confirm that answer with him. So on the 2017 accounts, where we're at in my submission is that it is effectively agreed on the evidence and by the parties that there were defaults that were disclosed in those accounts, which ALAWWAL's main and key witness, and the guy dealing with all of it, says, had I read it, I wouldn't have invested. And we say his evidence actually is inconsistent, because he then goes on to say, well, I did look at some of it. I did not read it. I looked at note 9, I looked at note 7, and I looked at note 8, and that records what was going on at the time. And then, Your Honour, where we get to in terms of the relevance of the 2017 accounts is I say it's relevant and limited in two ways, and that's how it has to be looked at. And that's whether Ribble told ALAWWAL there were no defaults in the fund, and whether ALAWWAL relied or reasonably relied on that alleged representation. Now, the one other area where it may have importance, Your Honour, it goes to the point that you raised with my learned friend about continuing duty.
Yeah.
It may be relevant to that.
Well, the continuing duty, or whether, given what was in the 2017 account signed off in September, representations made as late as February were true, because the obvious question is, well, what's happened between September and February? I mean,
yes.
the allegations I understand
Yes.
is that any defaults were, get exactly, limited and small scale and sporadic, or something like that, is what's said about it.
Mr. Swatt's evidence in his witness statement, he says sporadic defaults. But again, just on that point, John, I would say, well, you look at it in context. If you're looking at what the investment management report says, which is what ALAWWAL rely on, and you saw about 6 or 7 names that were listed there, that's in the context of hundreds of transactions that the fund undertakes. It's not lending to just these 6. It's engaged in hundreds of transactions.
No, I mean, of course, the point which goes against you is that the whole basis of this trade credit lending is that you're meant to be lending. I mean, I need to be a little careful because there are Islamic finance issues in relation to it. But in broad terms, what you're meant to be doing is lending against genuine receivables, which are real debts which are owed by real parties in respect of real goods. And if someone has shipped 10 tons of steel and they send an invoice for those 10 tons of steel for however much 10 tons of steel costs, and they get trade finance credit against it, and they then ensure that it's not secured lending in a sort of technical sense, although there may be lending with security, but it's very different from giving unsecured loans in relation to and so if you're in that sort of environment and you're lending on any view high percentages of the amounts of those, if you start getting even a few defaults, then what was looking profitable becomes unprofitable and perhaps more material for a fund. What was looking like a growing fund starts looking like a declining fund.
Your Honour makes a fair observation, but my point on that is, so what? Well, what's the relevance of it to the pleaded claim as it is?
Yeah.
Because the pleaded claim as it is, and the evidence that matches it is, had we seen these notes, that would have been enough to stop us investing. In our case, well, you were sent them. You say you didn't read them, but actually Mr. Ali Ibrahim's evidence is he looked at the notes, and I'll come to it in due course in my submission.
I mean, I think what Mr. Ali Ibrahim said about that we need to look at quite carefully.
Yes.
Because I think he probably said slightly different things on slightly different occasions. But anyway.
He did, yes, Your Honour. But that is something I will come back to. But I say it's much more limited, and this is why the accounting treatment or what should have been included in September and all that, I don't accept it's actually correct, but it's also, and Your Honour made the observation, which I agree with, and I would submit it be a big bold finding for Your Honour.
I mean, at the moment, I mean, there's a question which you can address me on as to whether I'd be entitled to make it, given the evidence I've heard, and as I use the word bold, but I do actually wonder whether it's necessary in any event.
My answer is no, Your Honour, it's not necessary. For 2 reasons, or possibly 3 reasons. The first is nothing's pleaded in respect to this in that way. The second is, in my submission, Your Honour can't reasonably dispose of that issue or make a finding without expert evidence.
Yes.
And the third and quite critical point is, contrary to the way in which the case is put, these are not accounts that are created by Ribble. Ribble contributes to the accounts. It's something that it's the administrator's responsibility, but important and critically, KPMG have prepared and audited 2017, 2018, 2019 accounts, and they've given unqualified auditor's opinion that the presentation of the information in there is fair and accurate. So what you do have is, and we must not forget that these are independent auditor verifications.
Yeah, I mean, I get that. I mean, I mean, we probably had this in the cross-examination of Mr. Stewart, but it's one thing to refer to reliance on independent audited accounts if you're anyone other than the director. It's rather less so if you're the director, because we know that there are management representations and so on and so forth which go into it, and quite who actually prepared the initial accounts. You tell me it's the administrator. I'm not saying you're wrong about that, but as we all know, the position in law is the directors are responsible for the statements,
yes.
and it's the auditors who say whether or not the views of the directors are fair and reasonable.
Yes, and I agree with Your Honour, and I don't seek to take a different position. The ultimate responsibility for the accounts are the directors who sign them, and that's a settled position in law. But that doesn't take away from the fact that what happens, as always, with directors, and as is the case here, is they delegate the responsibility to those who are actually experts and qualified to do that. And in this case, it's KPMG. And I just want to, whilst I'm here, Your Honour, my learned friend referred to it again, but I want to be quite emphatic about this. There was a suggestion made both during the cross-examination as well as in the submissions about the reason why PwC were dismissed.
He put it to your clients and it was rejected.
Yes.
That PwC in effect had resigned because they weren't happy about the asset treatment. That's what he put. So there is no evidence to that effect. He invites me to say that's the natural inference from, I think, a combination of the fact that your clients parted company with PwC and everything was done very late. That's the evidential.
Yes, and in my submission, there's no natural inference to draw from that because there is no premise on which to invite Your Honour to make that. He goes to no document or evidence that supports it. The only evidence you have on it is from the two individuals who gave evidence who were involved, which is PwC were dismissed because they were late. And actually, where I say that is supported is that in 2017 the accounts were late, and in 2018 and 2019 when KPMG are on board, they're filed on time.
Yeah.
So I say there's absolutely nothing to that point, and there's no inference or natural inference, I think, as it was put, that comes on from there. So Your Honour, that's what we say in respect of, there's been an attempt to drastically widen the scope of the case in respect to the 2017 accounts, and I say let's all step back and get to reality of what bleeding is. So Your Honour, with that, what I'll do is move on to the second topic I would like to address you on, which is the approach, or the court's approach to evidence. And the approach of the DIFC courts in assessing the evidence is more or less consistent with the approach taken by the English courts, which Your Honour will undoubtedly be familiar with.
Yeah.
And there are three submissions I would like to make about how you should approach the evidence. Now, the first submission is that in assessing all of the evidence, I invite you to apply the approach set out in the Crown on behalf of Dutton and GMC, which summarises the principles established by Mr. Justice Leggett, as he then was in England, in Guessman and Credit Suisse. And that reflects, Your Honour, the appropriate and correct approach that I say the DIFC court should and does adopt when assessing evidence, particularly when weighing the relative significance of documentary evidence versus oral evidence in relation to matters that were some time ago. Now, there are a number of points in Dutta that we emphasise. If I can just ask Your Honour to look at that authority, it's at E2, document 14, page 14. Paragraph 39 is what I'm specifically looking at. It's a fairly long quote, Your Honour, over the 3 pages. I would invite you to read that in the course of...
I really used to.
Yes, I'm grateful, Your Honour. So then, just in terms of what are what I would say are the principles coming out of here, is firstly, it's that memories are believed to be more fanciful than they are, and then there's faithful than they are, and there's two common errors to suppose it. The first is that the strong and more vivid the recollection, the more likely it is to be accurate, and the more confident another person is in their recollection, the more likely it is to be accurate. The next point is that the process of civil litigation serves the memories of witnesses to powerful biases, and we say that is very much at play here for reasons I'll come on to. The third point is there is a considerable interference with memory by the procedure of preparing for trial. Witness statements are often taken a long time after the events, and they're drafted by a lawyer who's conscious of the significance for the issues in the case of what the witness does or does not say. The next point is that the best approach for the judge is to base factual findings on inferences drawn from the documentary evidence and the known or probable facts. And that is certainly what we invite Your Honour to do, particularly in respect of the oral representations. And the last point is the witnesses, especially those who are emotional, who think they are morally in the right, tend very easily and unconsciously to conjure up a legal right that did not exist. So those principles...
Just on the
Yes.
documentary point, I mean, first of all, I was obviously familiar with these points. And one of the tensions which has emerged in civil procedure generally, but actually is particularly applicable here in the DIFC, is that two things have really occurred in relation to civil procedure simultaneously. Three things have occurred in relation to civil procedure generally. The first is that the amount of documents actually recording matters contemporaneously has increased.
Yes.
Emails, WhatsApps, and so forth. Second is the development of the jurisprudence, which we are looking at the moment, which points to the fallibility of memory. But the third is that because of the proliferation of documents, and in order to avoid the costs of litigation going through the roof, courts, including in particular those in the DIFC, have restricted the amount of documents produced on disclosure. So
Yes.
we don't have, for example, and I'm not saying that I would welcome them, but we don't have, for example, the WhatsApps, if there were any, which were passed between the representatives of the defendants immediately before and after the relevant meeting. Now,
Yes.
if those WhatsApps on the one hand had said, look, we need to be very careful about what we're going to be saying here, etc., etc. On the other hand, if they said, we've got a bunch of people coming in who were about to fleece, one could see one could come to very different conclusions. And the point I'm really making is that it's you need to be quite careful when considering this as to what documents you have got, what have been ordered to be produced, and what documents you haven't got. Now here we've got the emails passing between the parties, common documents. We've got the documents actually produced, the RFP and the presentation.
Yes.
But we haven't got, as far as I'm aware, anything approaching standard disclosure relating to any issue as to what, for example, your client said in relation to the meeting. And you know, that's just not how DIFC document production works.
Yes.
And it just seems to me that one needs to be aware, to add to these principles, what documents have been ordered to be produced and what documents haven't.
Yes. And it's a fair observation that Your Honour makes. So the other point I would add to that is under the DIFC rules for production of documents, what you are intended to, at least in the first instance, you're providing the documents that you yourself
Rely on.
support on.
Yeah.
That support your case and that you rely on. And then we do have the ability, as Your Honour is well aware, to have production requests.
But they're effectively governed by a version of the IBA rules, where they've got to be
Yes.
narrow and specific classes of documents.
Narrow specific documents, but relevant documents that ultimately go to the material disposure of issues. But
I mean, the only point I'm really making here is that when one comes to evaluation of the evidence, I'm well aware of these if I was starting again, maybe I'll do it in this judgment, I might also add that there is something of attention here, and the judge always needs to remember what documents he has got and what documents he hasn't.
Yes, yes. Your Honour is right, but just on that, and specific to this case, it's not in the bundle, but it was in our, for example, our request number 1 for document production, is we asked for documents referring to or relating to the meetings.
Yeah.
Now, on one analysis, and I would say the correct analysis, that would capture, for example, WhatsApps.
Well, it would capsize WhatsApp.
Yes, yes, of course, because the request is being made to the other side. But what we have here, Your Honour, and it's one of the points I'm going to come on to, is we did have WhatsApps that were provided, but they were provided, I think, the day of day 1. I think the pre-reading day, but I think that's the day in which they were provided. And I did ask Mr. Ali Ibrahim about, well, where are your WhatsApps with Mr. Zographos? But those are the key ones that go missing.
But in a sense, that rather emphasises the point that I'm making. I mean, you would say, well, you need to bear in mind that in relation to this oral evidence, which is given by the claimant's witnesses, they've produced WhatsApps with other people. They haven't produced WhatsApps going between themselves.
Yes. Good. Your Honour's quite right.
And on the other hand, Mr. Adair would be saying, well, we haven't got anything at all from Mr. Zographos.
Yes.
If that's the case.
Yes. Yes, and I'm going to come on to that part. But I think that the point is still within this let's say, extension to the principles that Your Honour identifies. The general point remains a good one, which is given the passage of time, I think particularly in this case where we're talking 6 or 7 years, the documentary evidence that you do have in front of you, as well as what we say are the inherent probabilities that arise from the evidence as a whole, are the most reliable guide in assisting the court in making its findings, rather than just the oral evidence. And the second point that I wanted to make in respect of this first submission is about the witnesses that were presented by ALAWWAL, which is Mr. Ali Ibrahim and Mr. Malachi.
Yeah.
Now, Your Honour, in my submission, both were highly unreliable witnesses, and I will come on to the reasons why I say that is. But in my submission, both of them did not attend court for the purposes of assisting Your Honour with the truth of the facts that were in their knowledge. Rather, they came to court to argue their case, to make speeches, to refuse to make concessions, important concessions in some respects, where it goes against, as it were, the ALAWWAL case. So we say they didn't come here to assist the court. Their primary objective appears to have been to just argue their position. And there are two aspects to that, which I say support that submission. The first is when one looks at the witness statements that they actually produced, and Your Honour, I'm sure, has considered them well, they fail to meet in my submission what is actually the rules under the RDC, so it's 29.18, as to what witness statements for trial are required to have. Now, what if Your Honour was to look at that, you'll see that witness statements are required to be in a witness's own words, they shouldn't contain lengthy quotations from documents, and they shouldn't engage in argument. And we would say, in respect of all three of those requirements, both witness statements did that. And in my submission, the inference to be drawn from that is that these are witness statements that were clearly drafted by lawyers, with one eye on the issue in dispute, which is one of the things we need to guard against. In my submission, those witness statements, they trawl through the documentary record, often documents that they would not have been privy to or in possession of at the material time, but documents that were given in production that they then seek to make comments on. So they engage in extensive argument for that particular reason. And one of the examples that immediately jumps out is in both of their witness statements. They both talk and they seek to opine on what they consider Mr. Zographos ought to have known or did know prior to the meeting. Well, that's quite rightly an assessment for Your Honour. It's not an assessment for these witnesses to make. So quite why they're giving evidence on that goes to the point that they're just here to argue the case. They're not here to assist the court. And the second point I wish to make is that both of their oral evidence was, in my submission, deeply unsatisfactory in many respects. They were frequently evasive under cross-examination. They often gave implausible answers. And as I say, they often sought to argue the case or to answer a question that wasn't being asked, just to get home the point about this is what ALAWWAL's case is. And somewhat inevitably, because his cross-examination was longer, we say Mr. Al-Ibrahim particularly was prone to just giving speeches that had nothing to do with the questions he was being asked, but rather he was just attempting to put forward ALAWWAL's case. Now, the other criticism that I do have of the evidence, and I will get into this as I go through my submissions, is that a lot of their oral evidence did not match up with what is said in their own witness statements or the documents. Now, I will take your honour to some key examples of this. And what the court will need to do is consider those transcripts we say in detail and very carefully. But it is important to highlight some key examples of the unsatisfactory nature of their evidence and show where some of the themes emerge that I've made submissions on. Your Honour, I will provide the crib sheet which has all the references to the transcript.
Good.
That has this. So if Your Honour would like to see any of them specifically, I do have the references. I can take.
Well, no. I mean, to be honest, I think that this is a classic example where you're better off giving me the references, and I can look them up.
Yes.
I mean, the references would, I think, be more useful if, at the very least, they identify what it's about.
Yes. That is what they do.
Yeah. I mean, you don't need to set out what the examples are. I can look those
Yes.
up. But if I'm thinking, well, that's not how I remember it, then,
Yes.
then I'll go and have a look at it.
Perfect. I'm grateful for that, Your Honour. But so what I think I set out about 8 examples in
Yeah,
that
okay.
outline scope. So I'm going for Mr. Al-Ibrahim. I'm going to just give you four main ones that I think provide kind of what I say.
When you say give them, you're going to read them out.
No, I'm not going to read out. I'm just going to give you
You're going to identify
the
them.
summary of what the
Yeah.
evidence is and,
Yeah.
and why it falls into.
I mean, it's up to you.
Yes.
That may be better done tomorrow when I've got the written sheet, because especially if I'm going to get it beforehand, I might even have a quick look at them beforehand, and we may go faster.
Yes. Well, Your Honour, I'm very happy to.
There's always the danger if you do start doing now of me saying, well, that's not how I remember it. And
Yes.
then we go and look at it in a rather unsatisfactory way.
Your Honour, I will then. What I will do is come back to that point in the morning.
I think that will be more sensible.
It will be better if I may just make a note of that. And what I'll do in the last kind of 10 minutes that I have is just deal with what is my last point on the court's approach to the evidence, which is the invitation my learned friend made to you to draw adverse inferences.
Yeah.
Now, my learned friend relied on, I think, the Wisniewski
I
decision.
mean, there's a lot of law about Wisniewski these days.
That is, yes.
It seems to come out from just about every single case that's along the way. But
Yes.
the starting point before one gets anywhere, it seems to me, is that there's got to be no reason given for them not to be called, an expectation they would have been called.
Yes. Well, but before that, Your Honour, I mean, we've cited Aphobia and Royal Mail Group as a more recent Supreme Court case on adverse inferences. Your Honour will undoubtedly probably also be familiar with, for example, Mrs. Justice Cockrell's decision in McDee.
She's given several decisions. I think.
Several where she says that the actual drawing of adverse inferences is something that is to be deprecated by the court now. But,
Yeah,
but
I think she could be said to be on the extreme end of being
she
quite
is,
hostile.
yes, she could be said to be on the extreme end, Your Honour. But what is consistent in all the decisions that come out, and it's a point Your Honour did pick up on, is that the party inviting the court to draw an adverse inference first must identify the precise inference it is asking the court to be drawn.
Well, that was why I asked Mr. Adair about it.
You did ask Mr. Adair about this, Your Honour, and in my submission, respectfully, he didn't give you one that was a precise
Well, I think
inference to
when
be
I
drawn.
proffered it to him twice, he did more or less come along with the unlikely to have supported their case, which
Yes.
I think is the appropriate inference normally.
Well, say for I would say that's not the appropriate inference in this particular case,
Well, sorry.
because
Would be the appropriate inference, if any. But
of any, yes, and I would say that the court should not draw that inference because Mr. Zographos is not an employee of
No.
Ribble.
Well, the evidence seems to me that to show that in relation to 2 of the 3 witnesses, they're no longer employed by your company.
Yes.
Now, you didn't adduce any evidence to the effect that they were unwilling to give evidence, or you couldn't get hold of them, or anything like that.
Yes.
On the other hand, you would say it's 5 years ago, and is there really a basis for saying that you could have got someone along to?
Well, that's right, Sean. And Mr. Zographos is obviously the key, as it were.
Yeah.
He's where the focus is. But what there is evidence before the court is that he left Ribble in 2019. Now, at the time witness statements and everything were done, it was last year. That is 5 years ago. Your Honour, it's not in the evidence, so but we can provide it if necessary. We had contacted him and asked him to assist, and he said no. He said, "Go away. I don't want you contact."
I'm not sure you can start giving
But,
evidence at this stage on those matters.
Well, I'm not giving evidence about it, but this is.
It did sound a bit as if you were.
Well, my point is still. Yes. Well, this is the other point. Is we haven't really been asked about it. Although I take Your Honour's point, we could have volunteered this in a witness statement or something. But
or just on that, it's perfectly plain that in the pleaded case, the main person who was alleged to have been making these statements was Mr. Zographos.
Yes.
I don't think saying you haven't been asked about it is an answer to that, actually.
I take the point, Your Honour. But leaving aside whatever that may be, my main point on that is a good one, which is you are talking about someone that is not in Ribble's control,
Yeah.
and not an employee. They left 5 years ago.
Yeah.
Even if there is no evidence about our attempts to contact him, I don't think there's any suggestion that we could have compelled him in some way to come and give evidence.
Where he is, but anyway.
It depends where it is, but there's also what there isn't, Your Honour, and I think this is a point I'm entitled to make, is we have no evidence that the other side sought to contact him to assist them with their case, which is one of the points that Your Honour is entitled to take into account when considering whether to draw adverse inferences.
Look, I haven't looked at this. I mean, I don't know, for example, whether there's anything in the pre-trial material which says whether people were or were not intending to call witnesses and so forth. Sometimes you find that someone has said they're going to be calling someone as
In a
witness.
case management information sheet, yes. I don't believe there was, Your Honour, but I don't have the documents to hand. But we say in any event, Your Honour.
I mean, put it another way. If he was still employed by you and he wasn't giving evidence, I think Mr. Adair might have a pretty reasonable ground for saying this was a case where your point is that in the modern environment, for something which is 5 years ago, even if you don't have evidence that you've tried and failed, then you don't get off the ground in relation to that. I assume what your point is.
It is, Your Honour, yes. So, Your Honour, that brings me quite neatly to the end of the topic about the court's approach to evidence.
Okay, well, look, I think we'll stop now. Just on timing, I'm taking it there will be no difficulty in finishing the submissions within normal time tomorrow, and even possibly finishing a little bit early.
Yes. I suspect so, Your Honour. I suspect it will come to be done by
Fine.
PM.
On this note of yours, if you can get it to me, well, actually, I've got something else after court, so if it were possible to get it to me at any time this evening,
Yes.
I will be able to have a look through it first thing tomorrow, which might speed things up before we
Yes.
come to court.
I'm grateful. We will certainly try to make sure you have it by this evening.
Good. All right, well, in that case, 10 o'clock tomorrow morning.
I'm grateful, Your Honour.